And I have Steve here with me. He's not going to log in separately tonight. He's sitting right next to me. So, all right, if you're in the chat in the call and you can hear us, give me a wave. I want to see if everyone else can hear. We can hear one another. Okay, fantastic. Hopefully it'll be clear tonight and we won't have the problems that we had a few weeks ago. So, you guys, tonight we're going to talk about the argument in the Supreme Court a few days ago about whether or not a former president of the United States has immunity from criminal prosecution. Wow, what an argument. Let me throw this general question to you guys first. Steve and I were just talking about this a few minutes ago. It seemed to me that this case was the argument and the way the case is put before the Supreme Court is very much less refined or honed down than what they're used to hearing. So the argument was all over the place. What do you guys think about that, sort of just generally first?
Let me start. I agree. There were theories coming out of the woodwork from all sides, and it stems from the D.C. Court of Appeals decision that, as Justice Roberts put it, was basically a tautology. The government can prosecute a former president because it did prosecute a former president.
Right.
That was the rationale.
Right. And that's the first on my list of topics for us to cover was his reaction to that, because I thought that was very interesting and unusual. Ship, on the big picture point, what do you think? I mean, sounded like some of them were thinking up stuff as they were sitting there. That doesn't usually happen in this court.
Well, I think it's a function of a couple of things. It's a question of first impression.
Yeah,
the
sure.
only guide star is Nixon versus Fitzgerald, and he's way away from that to say, well, that's a civil case. And, the importance of, having adequate enforcement of criminal statutes is a different question. So that's the first point. The second point is that there was no meaningful work done below.
Right. I think that's the biggest thing.
Yeah, in the trial court, the judge just waved it off and said, oh, we can't have that. And then, the appeals court said, oh, well, the trial court's correct. We can't have that.
We agree. That's crazy. Right. Yeah.
And the tautology, as I heard it, and I thought it was great that, King says that Roberts called it that. No, Roberts forced Dreeben to call it that.
Yeah.
Roberts got, and there's a backhanded slap in there.
Right, there is. Yeah.
The backhanded slap was when Dreeben said, I'm here to defend the appellate court's judgment. Meaning they got the outcome right, but don't ask me to defend how they got there.
Their reasoning or lack thereof. Right. Yeah, exactly.
And that's code. That's code speak that a lot of people will not understand. And I just sort of chuckled when he said, I'm here to defend the appellate court's judgment.
Exactly. All right. So you've hit upon what I want to do tonight, which is Steve and I have this afternoon, we've made a list. So I'm going to raise topic after topic after topic, because what I want to do is help people understand not just how we think it's going to come out, because we've talked about this for months now, right? But also what happened at the argument, because there was a lot of, as you say, Ship, like a lot of code in there, a lot of things that lawyers would get, but lay people are not going to. So on a very technical point, I want to let people know that if you listen to the argument or if you read the transcripts, you will hear the lawyers, Sauer for the former president, Donald Trump, and Dreeben for the special counsel, Jack Smith. You will hear them referring to their friend, or the justices will say, well, your friend argued this, or your friend says blah, blah, blah. And, this is also a code word. So in the Supreme Court, that is the way the justices and the lawyers refer to the other advocate, not as their opponent or their adversary or the other party. So it's a form of courtesy and custom in the Supreme Court that they refer to the other lawyer arguing as their friend. Now, I'm going to ask Steve about this. In the old days, kind of before women hit the bar, the advocates would refer to one another as brother, my brother at the bar. So if you read old cases like from the 1800s and the early part of the 1900s, that's the formulation that they're using. Now they say friend, and I'm wondering if that is just because women started practicing in the court. Do you have any idea, Steve? When did that change?
Nope.
Okay, so that's a historical point. We may have to research that. But if you heard them and wondered what friend are they talking about, who the hell are they referring to? They're talking about one another. So Dreeben is talking about Sauer is talking about Dreeben, and the justices are talking about both of them. Okay, so
Let me add something here.
oh yeah, go ahead.
It's my opinion, without doing a lot of research, but having been over in London on litigation, that collegial respect and and apparent affection stems from the English common law
Uh-huh.
courts and the way they try cases over there
Right.
for
It's an
for
effort to try
time
to,
and
yeah, from time immemorial. Um, so since the beginning of time, as Justice Ketanji Brown Jackson said.
Yeah.
Um, but it's a way of trying to take the personal out of the argument, don't you think, King, and just stick to the issues. King, would you agree with that?
I agree with that, but it's more than that. It it's meant to convey respect for the profession,
Right.
and above all, I think that's what is intended to convey, not only to the members of the profession, but the members of the public who are there listening. That this is a noble profession, and you should take lawyers seriously. Should take their ethical duties seriously, and they show that by showing respect to not only the court but their opponent.
Right. Another aspect of that we heard is, and one of my folks on Twitter asked about this, multiple times through the argument, there were suggestions that prosecutions of a former president could be political or be politically motivated. And the justice who was positing this was always careful to say that they were not accusing the current special counsel of doing that. Right? Now, a bunch of us think that that's exactly what's happening, but for purposes of standing there and arguing it, that would seem like a personal attack that then the advocate would have to defend, Mr. Draven. So, so the justices, they may or may not think in their own minds that that's what's going on, but in the midst of this argument, they are going to be careful to say, oh, we're not accusing you of that. Comments on that, you guys?
Yeah, I think that is, and that's also part of the aspect of appellate advocacy that you're limited, or you try to limit yourself to the record, and there's no record of that. So that would be a justice essentially introducing into the content of the case a personal view.
Right.
Well, what I'll say is this, which is the justices said, and I think truthfully, that they are wrestling with this case not just in the context of Donald Trump, but in the context of history of this country for the next 100 years or however long it may uh, survive with the whoever the president may be. So they don't need to say that there is definite evidence of political prosecutions. Having said that, it cannot. It's got to be the case that 5 or 6 members of that court uh, believe that we've got current examples, Alvin Bragg, Fannie Willis, of prosecutors who are prepared, perfectly prepared, to be political and to go after someone for political reasons. So they don't think it's an imaginary concern.
Right. They didn't specifically say that in the argument. They're being courteous to Mr. Dreeben by saying, we're not saying you're doing that, But it's obvious from some of the topics we're going to cover tonight that they are concerned about that and that they don't think that's an academic question only.
Let me say that Justice Gorsuch came right up to the line
Yeah.
when he talked about mostly peaceful
Protest.
demonstrations and protests.
Right.
He. I mean, there's a lot of history in that sentence.
Right. Yeah.
Well,
He continues to press on that meme.
if he came up to the line, Justice Kavanaugh picked his foot up off the ground and kind of waved it over the top as if he was going to step over. When he drew the historical analog to the independent counsel,
Yeah.
and very pointedly said, the design of that, whether, by intentionally or just by the way it worked out, was that a political partisan from the opposite party was picked to investigate the opposing president.
The current president.
And
Right.
in effect, we know how that turned out. And
Right.
how is this not really just an analog
Right.
or a mirror image of the same problem?
Right. I have that on my list of topics here. So, all right, so let's get started. So, the first one is the one you guys identified first, which is Justice Roberts, the chief, right off the bat, in Mr. Dreeben. So, this is a special counsel's lawyer, the government. Right off the bat at the start of that argument. So you guys who didn't listen to the argument know. So the president is the one who has asked the court to hear his case. So his lawyer went first, Mr. Sauer. But the first topic we're going to talk about is the first topic that came up with the other lawyer, Mr. Dreeben, arguing for the government. So Dreeben gets up, and Roberts, who often passes in the first round of questions, the way they do it now post-COVID is they go down the list of justices by seniority. It used to be in the old days. The last time, Steve, you were there, they were still doing it the old way, right? Where you just get peppered by questions from the justices as they can fit them in, and they talk over each other, blah, blah, blah. Now they go down the list of justices in order of seniority, and Roberts, as the chief, is entitled to go first. And in many arguments, he does not ask a question in the first round. He just goes directly to Justice Thomas. And in the second round, then he will ask his question. But this time, he obviously was motivated because he jumped right in there with Dreeben, and as King has already said, and read him. What he said was the closest thing he could find to the holding of the D.C. Circuit's opinion, which was this sentence that basically amounted to, well, we think you can prosecute a president because that's what you're doing. We're in the middle of doing it now. And Ship, you're right. He invited Dreeben to comment on that, but the chief is not normally as kind of sarcastic as he was, sharp as he was in that. And even him articulating it as this was the closest thing I could find to a holding in their case, just all of the way he presented that to me communicated that Roberts thinks the Court of Appeals, to say it in the vernacular, did a shitty job of analyzing this case, that their holding is really, literally, he said to Dreeben, why should we not just issue an opinion that says that what the Court of Appeals decided is, quote, not the law? And that, well, I thought, was a breathtaking statement by the chief, that to say that the D.C. Circuit did something that's not the law, you would never hear that. So, what was you guys' response to that? What do you think?
my response, and I'm in the middle of writing a Substack article, and I've got it in there, so I'm
Go ahead.
time myself out of here. My response was, and this is what I wrote, it's like, the Chief Justice went all Nancy Pelosi in the State of the Union speech on the appeals court decision.
That's a good analogy. Like, rip this piece of garbage up, right?
That's great, Ship. My response was similar, and a lot of ha-hawing and giggling and whatnot. What was even more amazing was Dreeben's comeback to that.
Right.
He didn't try to defend what the D.C. Circuit did. He tried to come up with rationales kind of out of whole cloth,
right,
that would support their final judgment.
Well, they got it right, but let's ignore what they said. Yeah, what the reasons supposedly that they came up with.
Well,
On that point, real quick, just let me butt in here, Steve, for just a second. Then I'm anxious to hear what you have to say. I think it's significant that he said, "I represent the Department of Justice,"
Oh yes,
and
yeah.
the Solicitor General did not argue that. And I think that was the special counsel saying internally, Preligar's not up to the task. We need to have Dreeben do this, who has the respect of the justices, because he's going to have to do what the appellate court did not do.
That may be because multiple of the justices don't seem to have a whole lot of use for Preligar. But
well,
all right, let's hear what Steve has to say.
number one, I disagree with that. The special counsel chose Dreeben, who was in private practice at that point. He'd been in the SG's office for years and years, and finally went out into private practice. But he's the preeminent criminal appellate advocate in the Supreme Court in the last 20 years in terms of the number of cases he's done. And so Jack Smith chose him. He's an alumnus of the office. He was like the deputy solicitor general. And so the fact that he's arguing it rather than Preligar, to me, doesn't indicate a damn thing. But having said that, I want to go back to where I was coming in originally on this. If you look at the D.C. Circuit's decision, and I'm not a fan of it, but in fairness to the D.C. Circuit, if you conclude, as it did, that there is no such thing as presidential immunity once you're out of office, then the statement that if you're indicted, you're legally indicted is indeed an applicable statement of the law as to a former president.
Yeah, but it doesn't explain why that makes sense.
Well,
why that's legal.
All right. So the fact then, and that plays into all the points that have been made, is that nobody, not even Dreeben, was prepared to say that that's really the right analysis of it. But I just want to make the point that it's fair if you take that view of it, which is an extreme view.
So on this issue of tautology, in case folks don't know what that is, tautology is a statement that is purporting to explain something, but explains it by saying it is what it is. So it doesn't illuminate the issue in any way. So it's like defining a word by saying that the word means what the word means. A cat is a cat, and that's how you know it's a cat. I mean, that doesn't help you understand what a cat is. So, but I did think it was hilarious. Ship, you correctly point out, Roberts basically plopped that quote unquote holding from the circuit onto Dreeben and then said, what do you make of that? It was Dreeben who called it a tautology. And then we, like almost every person in the case from then on, did you guys notice this? Decided to use the word tautology. So I thought, oh, we're all showing how smart we all are, that we know what this word means. Although I did think a couple of the justices used the word incorrectly, so they may not know what it means. But just so folks know, that is what it is. And lawyers tend to use that word in a particular way also to mean this is an argument that doesn't tell you anything. It doesn't add any dimension to the point that you're trying to make. You're just using the point to make the point, which doesn't help you make the point or illuminate the point in any way.
I'm right because I'm right.
Yeah, I'm right because I'm right. So, all right. So, Robert,
let me jump in for just a second.
Yeah, go ahead.
I want to agree with what Steve said just a minute ago, and I think I even said more than one time that the appellate court was almost certainly going to affirm Chutkin because all of the existing case law as it existed pointed that direction. And it's not
their own case law. Yeah, right.
It's not the job of the appellate court to stray out and make law contrary to the law that is available, even if it's limited. And I think I'd said before, when the lefty legal beagles were saying, well, the Supreme Court doesn't have to take this up. This is a solid opinion, blah blah blah. The point I made at various times was, look, there's no presidential immunity until the Supreme Court says there's presidential immunity, and only the Supreme Court can say that. So now that does not necessarily defend the outcome. I mean, like Dreeben said, from their perspective, the appellate court's outcome was correct based on the law as it existed. The Supreme Court can change that law. I think the Supreme Court, and it wasn't just Justice Roberts. I mean, I've written and we'll talk about it. It's like Justice Roberts then was elbowed aside by Justice Kavanaugh, who then was
Yeah.
shoved alongside by Justice Gorsuch. All of
Right.
it.
Exactly.
Oh no, I forgot Justice Alito. He went first.
Alito. Oh, yeah.
And
Right. He
they all
did.
to basically pummel different parts of the appellate court's decision.
Right. So, turning for one last second to Justice Roberts' issue about the circuit, it seemed to me that the tone of his voice, he was a bit disgusted. And I got to thinking, why would that be? And then it occurred to me, they stood aside and did not take the special counsel's request to hear the case before the circuit ruled on it, right? They stood back and let the circuit rule. And it sort of had the flavor to me of, we let you guys rule on it, and this is the nonsense that you sent us. Come on.
Yeah,
Um,
after giving each side 7 days to brief it and argue it a
right,
week later and then produce an
right.
opinion in 6 weeks. It's like, what was the point?
What was the point? Exactly. You didn't help us. You, the District of Columbia Court of Appeals, didn't help us, the Supreme Court, with this. And back to my point then of, it wasn't, the arguments weren't honed. They're used to hearing cases of first impression or where there's no real law and they have to make the decision. What they're not used to is deciding cases where the issues haven't been refined and clarified. And I thought it really showed in this argument. Okay, so another sort of term of art that was used that I want to explain up front, because I think we're going to need to use it for several of the other points, is what the special counsel, Mr. Dreeben, called an as applied challenge. So I want to make sure people understand this first. So the easiest way to understand this, I think, is the First Amendment case. So let's say you have a statute and it says you're not allowed to do certain things. And somebody's being prosecuted under that statute. And they may say, well, I have a First Amendment right to do what I was doing. And you can't prosecute me under this statute because the First Amendment gives me the right to do what I was doing. So as a defense lawyer, there's two ways to use the First Amendment to attack that statute. The first is an on its face challenge. So you can attack the statute by saying it does not matter what the facts are. If you just look at what the statute literally says, no matter what facts you come up with, if you're going to use this statute, you're always going to be violating the First Amendment. So these would be statutes saying, a gross example would be, you're not allowed to say that you don't like the New York Mets, right? You're just not allowed to say that. If you do, we're going to send you to Rikers Island. So on its face, that just would violate the Constitution, the First Amendment. So that's an on its face challenge. But there is also this secondary idea, which is called an as applied challenge, meaning that on the literal language of the statute, it might not violate the First Amendment, but the way the statute is structured or the language in it creates a situation where it's going to cover conduct that is both protected by the First Amendment and not protected by the First Amendment. And in that case, you defend on the grounds that as applied to your client, this statute violates the First Amendment because they have a First Amendment right to do whatever it was they were doing. So that's what the easiest example of as applied means, is in the First Amendment context. But here, the parties are arguing over whether a former president has immunity for criminal prosecution. And the Supreme Court's question presented it exactly that way. Is there such a form of immunity and for official acts? And so then the parties are arguing that. But then what happened was we got into what I've written in my notes as word games, basically. So Mr. Dreeben is saying that the former president could defend in this as applied way by saying, well, your prosecution of me infringes on my powers as a president, and launch a launch, I guess, is an as applied challenge. He called it an as applied Article 2 challenge to the prosecution. Whereas the other side, Mr. Sauer, is arguing that the former president has immunity from criminal prosecution for official acts, meaning that you can't be prosecuted for it at all if whatever it is falls under the heading of official acts. So, one of the justices, Justice Gorsuch, really had no use for this word games nonsense. He uh, was very sharp, sarcastic with Dreeben, saying, you know, all this as applies. You mean immunity? I guess, like, whatever we're calling this. What we're really talking about is whether or not the former president can escape prosecution for it. But now that I've explained this idea of as applied, what did you guys make of this argument by the special counsel?
Can I start?
Sure, go ahead.
As applied is just one of several that Dreeben came up with as possible defenses that a former president might have to any prosecution. And in not just as applied challenge, but also something called public authority defense, something called core Article 2. He didn't call it immunity, but Justice Alito or Gorsuch did. But these were a series of defenses or
Like renaming. We're just going to call
hurdles.
it something else.
Yeah, he listed about 3 or 4 or 5 ways that basically Smith's case can be defended. And he at the end of the day, I got the impression that he didn't think much of Smith's case. Because do you agree, Steve?
Are you talking about Dreeben?
No, I don't. I don't agree. I think he was instead trying to offer up a justification for his position, which was the prosecution should proceed, and that these concerns that are expressed with respect to immunity, in other words, you're prosecuting the president for something that we've given him, charged him to do, and given him great discretion to do, and he ought to be able to raise that one way or another as a defense. And so I thought Dreeben was saying he can't do it in the form of immunity, but he could in an as applied challenge. Now, the difference, as we all know, there's a huge practical difference because immunity means you can't, the prosecution can't even proceed. The president can't be put on, or the former president can't be put on trial if he's got immunity. Whereas if you're doing one of these as applied things, then that would be raised prior to trial, presumably. That's the way it's normally done.
Yep.
It's raised prior to trial by the defense. And if the trial judge rules against you, then you've got to wait until after the trial to see if you're convicted. And if you're convicted, you take it up on appeal. So there's a huge practical difference between whether you call it immunity or an as applied constitutional challenge. And that's implicit in all of this back and forth that's going on at the Supreme Court.
Right. Gorsuch seemed to be trying to say, look, you guys are not that far apart. You're both saying that the president can't be prosecuted for certain things. You just don't agree on what those are.
Yeah, that's the way I took it. And that's the way I took Dreeben's argument that there are certain protected portions of the president's constitutional duties that he can't be prosecuted for. There's a procedural difference. Steve is right.
Yeah.
We think we should get him to the jury, let the jury decide, and if he's right on the law, he can take that up on appeal. That is the former president. But fundamentally, he's admitting that there are certain functions that the president has, and even in this case, which are at least doubtful as to whether they can be prosecuted. That's the way I took it.
Yeah, me too. But
Yeah,
Gorsuch, I thought, pinned it down to really this is you're just arguing semantics, right? You want to call it an as applied Article 2 challenge, which nobody had ever even heard of that before because the special counsel just made that up. Um,
Well,
or, or, or it's immunity. So kind of like, what's the difference? Ship, what were you going to say?
yeah. And I've listened to this exchange 2 or 3 times, a couple times just today, leading up to now, and writing my article. Gorsuch lost patience because
Yeah,
what
he
he
did.
said is, he said, you want to call it an Article, 2 applied challenge and or immunity. He said, well, can we just call it immunity for simplicity's sake? And because he
Right.
said, because regardless of whatever euphemism you apply to it, it comes out the same. Um, but Gorsuch went. Gorsuch said, yes, we've narrowed the dispute here because Dreeben admitted that there's this core set of presidential powers that Congress cannot intrude into, even through criminalization of conduct. So Congress, it's the president, the zenith of his authority under the Constitution on a separation of powers basis, as recognized in Youngstown Steel. Congress can't legislate in that zone, so they can't make anything in that zone criminal. And Dreeben had to acknowledge that, not only because it's a matter of established case law and constitutional principles and separation of powers, but also because it is the way out of the Obama drone striking the family problem.
Right. Right.
And they knew that was coming. The SEAL Team 6 hypo was comical, but the Obama drone striking the U.S. citizen is not comical. And so they needed a way out of that problem. So they come up with these, the one little bucket is these narrowly defined core powers of the Constitution, which is, in effect, immunity. And so
Right. But he
right
doesn't
there,
want to call it immunity, which is
well,
why
right,
Gorsuch got annoyed. Yeah.
yeah, exactly. But right there, he had to break with the appellate court and the trial court. Right there,
Right.
that's
Exactly.
his admission that the appellate court and trial court were wrong,
We're wrong.
because
Yeah,
Right.
there
At that
is.
point.
And
Right.
but
then
Exactly.
on the other end of the spectrum are purely private activities. And
Right.
then
no, but
which even Trump says, which even Sauer said, we're not claiming that those are subject to immunity. And so Gorsuch would say, okay, so now we know that we're talking about this bucket of conduct in the middle that
In the
we're going to
middle.
describe as official. The question is the differing definitions of
The
what
scope of that.
falls within
Right.
that. But
Right.
then
Smith,
what Gorsuch
sh-
went to,
Hold on,
hang on,
King. I'm
Kate.
going to get to you next. Yeah.
Gorsuch's point was defining that middle is where the problem begins. Not
Right.
identifying that it exists,
Right.
but defining its parameters. And
Right. What's the scope?
how do you propose we do that?
Right. He wanted to talk about what they actually need to rule on in this case. Uh, so, King, what were you going to say?
I was going to say that I agree with Shep that it boils down to the middle. But Dreeben's argument in admitting that there was this core section of or portion of the president's functions that are protected not only differed from or varied from what the DC Circuit said, but it is contrary to what Smith argued in the lower courts.
I wondered about that because they all took that as if it was a huge concession. Now, I read his briefs, and I they never came right out and said, I didn't think even in briefing to this court, okay, maybe I missed it because maybe I did, but it did seem like that was a big concession in the argument that they're saying, yes, there are some things that the president just simply can't be prosecuted for, which I think everyone knew. So how in the world did the Court of Appeals come up with a decision that said otherwise? It just didn't make any sense from start to finish.
which is why Robert said what he said.
Right, exactly.
Well, and it's because the Court of Appeals said that a former president is just a private citizen. Doesn't The Court
Right.
of Appeals refused to go back and say decision making within the context and time as the presidency has to be insulated in some fashion. They said, well, once you're not president, you're not president.
Right.
Right.
And you're just like any John Doe. You can be just any other citizen, and if you get indicted, you get indicted.
Right. And Mr. Sauer said in his opening statement that that's wrong. And then there were literally no questions on that point from any justice that I can recall. So I think they agree with that, right? They're not at all bothered by that this is a former president we're talking about. Do we agree on that?
You had one justice at least came close to disagreeing with that. Justice Sotomayor raised the issue of uh, 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 conditional. She, the motive based immunity. That is, you're immune if you were in good faith.
Right. But she's not saying that your immunity, whatever it is, burns off on the day you leave office. I didn't read any of them as agreeing with that point.
No, I agree with that.
Yeah, but that was one of the circuit's holdings. I'm on record on Twitter as previously saying that point that somehow the your immunity as president just doesn't apply anymore the day after you leave office. That's one of the dumbest things I've ever seen in any appellate decision. It's clearly wrong.
And I think Roberts, with his comment, which I agree was sarcastic, it was very erudite. It didn't sound sarcastic,
Yeah.
but it was sarcastic as hell.
Right.
He was basically saying, "What the hell is this?"
Right. That's ridiculous. Okay, so they're not going to say that Trump doesn't have immunity because he's no longer the president. So that's off the table. And as we've all agreed, they're also not going to say that Tanya Chutkan and the Court of Appeals got it right by saying that the president has no immunity. So technically, that was the end of the case in a way. Trump won the case once that concession was made. But that's not really all they're going to have to decide, right? We're in agreement on that?
Well,
Yes.
not according to Justice Jackson in the last 10 minutes.
Yeah, we're going to get to that. Okay, so, and as we said, the multiple justices got both parties to confirm that private conduct can be prosecuted. Gorsuch wanted to take that off the table too. He's like, look, this idea that the president is a king and is above the law, that's nonsense. Nobody thinks that. Nobody in this room thinks that, right? Because he got both lawyers to agree that private conduct by the president could be prosecuted. Now, they didn't delve into whether you'd have to impeach him first if he was in office because they don't have to worry about that in this case. So, but then the rubber really hits the road because the question is not whether a president can be prosecuted for private conduct, but whether he can be prosecuted for official conduct. So the next topic go ahead, King.
I know you're heading to what conduct is in and
Yeah.
what conduct is out. Before you
Right.
get that, can we discuss the mens rea part of it, the motive? Because that was surprising to me. That it seems to be most people in the room kind of agreed that we don't want to go there in dissecting the underlying motive of the president for doing anything.
Surprisingly, there was agreement on that across the board. I thought I have it on my list, King, so we'll definitely get there. Okay, the next thing I have on the list is that both sort of sides, left and right, wanted to talk about the adverse consequences of each position. So if we adopt the special counsel's position, what incentives does that create and send? On the other hand, if we adopt the position of Mr. Sauer, who his position is that they should apply to the criminal side the same rule that the Supreme Court made on the civil side, which is that the president is not subject to liability, former or current probably, for any official acts that come within the outer perimeter of the scope of his duties. So Mr. Sauer says that should be the same rule on the criminal side. Dreeben arguing on the other side of the case that there are some core things that the president is immune for. He doesn't want to call it that, but that's what he's saying. But there are lots of things that he could still be prosecuted for that are official acts. So, but I wanted to talk for a few minutes about there seemed to be a divergence of views amongst the justices.
You can be just any other citizen, and if you get indicted, you get indicted.
Right. And Mr. Sauer said in his opening statement that that's wrong. And then there were literally no questions on that point from any justice that I can recall. So I think they agree with that, right? They're not at all bothered by that this is a former president we're talking about. Do we agree on that?
You had one justice at least came close to disagreeing with that. Justice Sotomayor raised the issue of uh, 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 conditional. She, the motive based immunity. That is, you're immune if you were in good faith.
Right. But she's not saying that your immunity, whatever it is, burns off on the day you leave office. I didn't read any of them as agreeing with that point.
No, I agree with that.
Yeah, but that was one of the circuit's holdings. I'm on record on Twitter as previously saying that point that somehow the your immunity as president just doesn't apply anymore the day after you leave office. That's one of the dumbest things I've ever seen in any appellate decision. It's clearly wrong.
And I think Roberts, with his comment, which I agree was sarcastic, it was very erudite. It didn't sound sarcastic,
Yeah.
but it was sarcastic as hell.
Right.
He is basically saying, what the hell is this?
Right. That's ridiculous. Okay, so they're not going to say that Trump doesn't have immunity because he's no longer the president. So that's off the table. And as we've all agreed, they're also not going to say that Tanya Chutkan and the Court of Appeals got it right by saying that the president has no immunity. So technically, that was the end of the case in a way. Trump won the case once that concession was made. But that's not really all they're going to have to decide, right? We're in agreement on that?
Well,
Yes.
not according to Justice Jackson in the last 10 minutes.
Yeah, we're going to get to that. Okay, so, and as we said, the multiple justices got both parties to confirm that private conduct can be prosecuted. Gorsuch wanted to take that off the table too. He's like, look, this idea that the president is a king and is above the law, that's nonsense. Nobody thinks that. Nobody in this room thinks that, right? Because he got both lawyers to agree that private conduct by the president could be prosecuted. Now, they didn't delve into whether you'd have to impeach him first if he was in office because they don't have to worry about that in this case. So, but then the rubber really hits the road because the question is not whether a president can be prosecuted for private conduct, but whether he can be prosecuted for official conduct. So the next topic go ahead, King.
I know you're heading to what conduct is in and
Yeah.
what conduct is out. Before you
Right.
get that, can we discuss the mens rea part of it, the motive? Because that was surprising to me. That it seems to be most people in the room kind of agreed that we don't want to go there in dissecting the underlying motive of the
Right.
president for doing
Right.
anything.
Surprisingly, there was agreement on that across the board. I thought I have it on my list, King. So we'll definitely get there. Okay. The next thing I have on the list is that both sort of sides, left and right, wanted to talk about the adverse consequences of each position. So, if we adopt the special counsel's position, what incentives does that create and send? On the other hand, if we adopt the position of Mr. Sauer, who his position is that they should apply to the criminal side the same rule that the Supreme Court made on the civil side, which is that the president is not subject to liability, former or current probably, um, for any official acts that come within the outer perimeter of the scope of his duties. So Mr. Sauer says that should be the same rule on the criminal side. Dreeben arguing on the other side of the case that there are some core things that the president is immune for. He doesn't want to call it that, but that's what he's saying. But there are lots of things that he could still be prosecuted for that are official acts. So, but I wanted to talk for a few minutes about there seemed to be a divergence of views amongst the justices about what was the worst adverse consequence that would flow. So the libs to me seemed like they were worried about incentivizing a president to act criminally in office, and the conservatives seemed to be more worried about political prosecutions after the person left office. So, what did you guys think of this debate about the consequences and incentivization?
Well, I mean, it comes down to the two sides talking about opposite sides of the same coin.
Right.
You know, I can't remember. I think at least three, if not four, of the so-called conservative justices on the court kept telling Dreeben, we don't need to hear about the facts in the indictment. We know the facts in the indictment. We're talking about a bigger principle on a forward-looking
Right.
basis. And the three more liberal female justices kept wanting to talk about Trump in the indictment. And so they're talking past each other in that sense. The two sides don't want to agree on what they're trying to accomplish with the decision.
Right.
Are they enacting a workable rule that has some prophylactic effect going forward, or are they just saying, we'll probably never have to wrestle with this again after Trump, so let's just feed Trump to the wolves and then we'll be done with it.
Right. They seem to place different values on what's the worst thing that we're trying to prevent. King, go ahead.
When that was going on, though, one of the justices changed the subject.
Yes, she did.
No, it was the chief. The chief cut off
Oh,
Dreeben.
I thought you were talking about Katanji cutting
Uh,
off Sour. Go
I'm
ahead.
talking
No,
no.
Dreeben was answering. He was answering questions and going on about all
Oh, yes.
the lawsuits that Trump had pursued and how he lost and the terrible things that he was trying to
Yeah.
do.
He went on a
Blah blah blah.
rant.
And
Yeah,
and Roberts cut him
he
off
did.
and went to another judge
And you
or
guys, that
justice.
doesn't usually happen either. Although I have heard the chief do that before when a lawyer starts just waxing poetic and goes off on a rant, and that's what happened. So the way the chief handles that is he says, "Thank you, counsel. Now over to Justice whatever who was next. I think it was Alito."
Well,
King, is that what you were talking about?
I was talking about you have this debate going on as to the effect of immunity versus non-immunity. If we make him immune, you risk a rogue president violating all of the laws, killing his opponent, assassinating his opponent, not following the law, etc.
Yeah, but who are you saying got cut off?
What's that?
You said that one of the justices cut one of the advocates off. Which one did you
No, that
mean?
was Ship talking about that. I'm talking
Oh,
about
yeah.
the debate between the justices who were worried about the effect of immunity. That is, you're going to end up with a rogue president who doesn't follow the law versus the other side who were worried about the strife that Sauer described, the political prosecutions, things like that, hamstringing a president so he can't perform his duties as head of the executive branch. That debate was going on. And in the middle of it, one of the justices raised another issue, changing the subject, and with this clear expression of Congress idea. Let's look at the statute and maybe we can construe the statute to give him immunity backdoor.
Right. This clear statement rule, which I have that on the list too, so we'll get to that. But you're right. They were going pretty hot and heavy on the consequences argument. And then one of them, I don't remember which one of them it was like, oh, well, I have a question about this other thing.
I think that was
Okay.
Justice Barrett.
Barrett, yeah.
Yeah.
Yeah, I think it was Justice Barrett, because she kind of a couple of times she strayed off like as a court of one,
Yes. Yes.
talking
She
about
tends
stuff
to
that
do that.
nobody else
She tends
suggested.
to do that. I've noticed she has like technical questions that she wants answered. Right. So, Steve, what were you going to say?
well, I was going to say that the focus here on what's the most adverse outcome. Let me start again. The Constitution says remarkably little about immunity. In fact, it says nothing about immunity. It does say that a president can be impeached, and it does say that a president can be prosecuted after he's impeached
and convicted.
So the Supreme Court, in trying to decide they're going to do here, is doing what it always does, which is looking to history, which is looking to the consequences, which is looking all around to any sort of source of information that it can find to inform its judgment. And the debate that King has laid out very accurately is at the heart of this. The liberals say, no man's above the law, and if the president comes into office knowing that he is basically immune from criminal prosecution, God knows what he'll do.
It'll be a crime center, said Justice Brown Jackson.
The conservatives are much more concerned about the practical consequences, saying, we're going to get into retributive conduct here, where one administration comes after its predecessor, followed by another. And of course, we've got an object lesson in terms of the Trump prosecutions, which it's hard for me to think of a better example than that. And so that's at the heart of this thing. But in terms of a Supreme Court justice, again, leaving aside the politics and the immediate implications here, just in terms of how you decide it does come down to the question of which do you think is the more realistic concern, which is the greater concern. And I think it's clear that the conservatives think the greater concern, and I agree with them, is these political prosecutions, particularly at the state level. And that I think that at the end of the day, when there's grasping for some middle ground, I'm not sure that they'll find a middle ground, but when they're trying to decide which way they come down on the whole thing, that's going to drive them saying, that is a more realistic concern than the concern that a president's going to start committing crimes left, right, and sideways because he or she thinks that they're immune from criminal prosecution.
Right. So that touches then on the next topic I wanted to cover, which is this impeachment. Now, there's been a lot of talk in the press, legal commentators, left, right, and just regular people on social media and so forth about, well, does the former president, does he have to have been impeached and convicted in order to be prosecuted? And there's arguments on both sides. So Mr. Sauer's argument for the former president is that the constitutional provision about impeachment and conviction basically says what it says. And so their position is that the former president had to have been impeached and convicted before he could be prosecuted for XYZ crimes. Mr. Dreeben's position for the special counsel is to the contrary. He says that basically his argument was that makes a difference. It makes a difference whether the person is currently in office or not. So he's basically saying that provision does not apply to former presidents because they're already not in office. So you don't have to go through that procedure. So you guys correct me if I'm wrong. I didn't hear any justice expressing any interest really in that idea, one way or the other. I mean, they made the parties clarify, yes, that's what your position is, but there wasn't a whole lot of debate by the justices on that. What do you guys think of this?
I took it as they look at it as a given if they find immunity, that the immunity is limited by the impeachment clause, because that's what Sauer admitted, that the president can always be impeached, and if he's convicted by the Senate, he then can be prosecuted. That's in the Constitution. So they accepted that as a given, that would be the result, and they really didn't want to debate that. They didn't want that to play any part in deciding whether there is or is not immunity.
Chip, what do you think of that?
Yeah, I noted, just as you said, that there was very little, if any, inquiry eye of the court into the historical meaning and the intention of the framers in the language they used to construct the impeachment judgment clause. And then I contrasted that lack of inquiry or interest with the appeals court,
Right.
where that was a subject of conversation that went on and on and
Right.
on about how and I think if you go back to the order from the trial court, it was a subject of quite a lot of discussion.
Right. But the Supremes weren't interested in that issue.
Not, I think because they recognize it's a dead end and it's a question that can't be answered and it misses the point.
Right. I agree.
It is self-evident that yes, if impeached and removed, the president can be prosecuted. The question whether he has immunity doesn't turn on the answer to what happens if he's not impeached. He either has immunity or he doesn't. And if he's not impeached, doesn't change that calculus. And so since Trump wasn't impeached or he wasn't removed, we don't have to go there in this case. What we're really talking about are these three buckets and how we manage these three buckets of allegations in the context of an indictment that's already been brought. Can it go forward or can it not go forward? Speechless?
Ship, you said it better than me.
Yeah.
I agree. Have we lost Leslie?
Okay. Can you hear me now? King, can you hear me?
Yes.
Okay.
I can hear you now.
Ship, I couldn't hear you for a while there. Say something. Let me see if I can hear you now.
How about, can you hear me?
Yeah.
King, talk to her. Can you hear me?
I can hear Ship. Leslie, can you?
No, I cannot.
All right, tell her I'm going to sign off and I'll come back.
Yeah. Ship, Leslie Ship's going to reboot and log back on.
Tell Leslie that she went all electronic right there, so it might be on her end.
If I say or whatever, it still doesn't do what it's supposed to do. All right, so Ship, I'm going to send you another invite to be the speaker, and hopefully that'll fix it. Okay, so on this question of the impeachment, Ship King, I sort of took it a different way. I don't think they're going to say that a former president has to be impeached and convicted in order to be prosecuted. I took their silence on that as differently than you did. So one of us is right. Maybe we're both wrong. They may just say we don't have to decide this.
Maybe I didn't articulate what I said. I think that if they find immunity, they will qualify that by saying he can be prosecuted if he's impeached and convicted, because that's what the Constitution says. But the impeachment clause itself will play little or no role in the decision of whether there's immunity. That's the way I read it.
I think that by applying, can you hear me?
I hear you now.
Okay. You sound really electronic to me. I can't understand everything you're saying. I don't know if that's me or you. But I'll just. I actually think the justices look at that as a de facto way to narrow the exposure to the constant recriminations. They don't have to come out and say a president has immunity, but if they reinforce the narrow construction given by Trump, they simply narrow the lane of the highway down which a criminal prosecution can proceed.
I mean, I could be reading it wrong, but I don't think they're going to do that. I think they're going to say if the president is former and not current, then he does not have to be impeached and convicted because it doesn't matter. And the only question is whether he's immune or not. But we'll
Leslie, now I've lost you. I can't hear.
Yeah. Ship, can you hear?
I just tried to switch over from cell to Wi-Fi, but it sounds like I've lost you.
I can hear you fine, Chip. I can't hear Leslie.
All right, test 1, 2, 3. Who can hear me? Thumbs up or thumbs down?
Okay. Ken, can you hear me now?
Yes, much better.
See, the problem is when Ship is on is when it cuts off. I just I dumped him. And now you can hear me, which is ridiculous. So, all right, he's requesting to add as a speaker. Ship, I'm going to invite you to be a co-host instead. Sometimes that fixes it, people say. So try to accept that one.
All right,
Okay.
how about how
Now,
about
Ship, I
how
hear
about
you.
now?
Can you
Yes,
hear
I can
me?
hear you. Can you hear me?
Yes. Ken, can you hear us both?
Yes, both.
Okay.
Okay. Maybe that has fixed it. All right. So we'll see what they say about the impeachment. So the next topic I have on the list is Kavanaugh going on and on about this independent counsel thing, which I thought was fascinating. And there was an article, oh, it's escaped me now, in one of the left-leaning publications about, I think it was maybe Politico, about, oh my God, how can Brett Kavanaugh, who was on the Star team, how can he be saying, this is just so terrible, blah, blah, blah. And I thought, where have you guys been? Kavanaugh is on record as saying that he, in the fullness of time, thinks that the independent counsel thing was actually not such a great idea. um, and he really hammered Reben about that, saying, isn't it kind of clear from the way that that statute worked and what happened under that statute that it's it becomes highly partisan really fast? And is that what we want? So just so people can understand, I don't remember when the independent counsel statute came into effect. Post Watergate in the 1980s. It was a post Watergate thing. It might even have been a little earlier than that, where the Congress passed a statute that said that under certain circumstances, the Attorney General was supposed to appoint this independent counsel. The independent counsel supposedly could not be removed by the president, could only be removed by a panel of judges, I think from the Court of Appeals or something. Anyway, they were trying to insulate an independent counsel to do investigations of the sitting president, was the point. So you can see, post Watergate, why they had concerns.
They're trying to avoid a repeat of the Saturday Night Massacre.
Right. Saturday Night Massacre, for folks who are too young to know this, is Richard Nixon decided to fire the independent
Attorney
counsel.
General, well, the independent counsel, and then the Attorney General, Deputy Attorney General.
Right. He wanted to. Can you hear me? Because it's telling me that I've lost connection again.
I can hear.
I hear you.
Okay, great. All right. So Nixon wanted to fire the independent counsel, but he couldn't do that directly. So he ordered the attorney general to do it. The attorney general said, that's not happening. And so he resigned instead. And then Nixon then ordered the next guy up, the deputy, whose name's escaping me. And he also said, that's not happening. And so he resigned instead. And then that left Robert Bork as the Solicitor General at the time of the United States. And Nixon told him, okay, you're going to fire the independent counsel. And Robert Bork was like, I don't want to do that. But he consulted with the two, the AG and the deputy AG who had previously resigned, and they told him somebody has to stay and run the Department of Justice. So don't resign. So he didn't. And of course, that was part of his legacy ever after Robert Bork. And became an issue when then he was later nominated to sit on the Supreme Court. So, in any event, that's the Saturday Night Massacre. So, the independent counsel statute came after that, trying to kind of protect prosecutors who were investigating the current president. And then, as you may know, if you are a little bit younger, or a little bit older than the newbies who won't know anything about this, 3 presidents were investigated by the independent counsel: Reagan, George H.W. Bush, and Bill Clinton, famously. And it just went from partisanship to partisanship. And so that statute lapsed. The Congress did not renew it. Did it have automatic sunset? It might have had an automatic sunset
Yes, it did.
provision, and they did not renew it. Basically because both sides' oxes had gotten good and gored with this statute. But before it lapsed, it was challenged as being unconstitutional because it took away from the president the power to fire an official of the Department of Justice, which doesn't make any sense. But the Supreme Court, in a famous case, Morrison v. Olson, said that that statute was constitutional over a very strong, vigorous defense by Justice Scalia, who I think that was his first year on the Supreme Court. And he made the argument, which I made to my professor in law school, that this statute cannot possibly be constitutional because it is not possible for the Congress to take away the president's power to fire an executive in the Attorney General's office and give that to the courts instead. But the Supreme Court at the time said it was constitutional, basically because everyone was so singed by the Nixon thing that they decided this somehow made sense. But Kavanaugh's point in the argument this week was, yeah, but we saw the lack of wisdom of that whole exercise and how political and partisan it did become. And Mr. Dreeben, isn't what the special counsel's office is doing now pretty much the same thing? You're asking us to say that presidents don't have any protection from prosecution for their official acts. And how is that not just going to end up in exactly the same kind of partisan tit for tat? As the administrations change, then they just go around prosecuting each other like we always say people in banana republics do. And isn't that really terrible? So that was Kavanaugh's position. What did you guys think of Dreeben's answer to that?
Can I start? You could tell.
King, are you
yes,
talking?
I'm talking. Can you hear me? Can you hear me?
Yes, he's talking, Leslie. I can hear him.
I cannot.
Should I talk or reboot or what?
Go ahead. Why don't you reboot and I'll go first, and then you can come in.
Yeah.
Okay. What that to me was almost like the prime example of the two sides talking past each other, because
yes,
Kavanaugh wanted to talk about the historical example that informs the court now as to how this is likely to play out going forward, and Dreeben wanted to talk about Trump. Dreeben said, well, it's not really a fear because we've only had 2 instances where this happened. It was Nixon and the current case. So it's really not something that we have to be too concerned with because we don't think future presidents will be, the same evil character as Trump, and that we'll have to go down this path again. So let's just do this case and let tomorrow take care of itself.
And ignore the fact of how that all worked out before.
Yeah,
exactly.
Right. That his defense or his argument was in essence that Trump is a one-off.
Right. Right, which isn't really an argument, I don't think.
But Iran-Contra was a one-off, right? Nothing bad happened after Iran-Contra.
Right, exactly. So, yeah. Now, I did think it was very interesting that Kavanaugh was the person who brought that up, right?
He knows his history.
Looks like Kingmaker's coming in as a co-host.
I've
Can you
returned.
Hear me now? Fantastic. All right, let's see if we can hear Ship now. Ship, can you hear both of us?
I can hear both of you,
Okay.
yes.
All right, this may be the solution, is that we all have to be co-hosts in order for this to work. Okay, so King, go ahead.
Yeah, my point was that this issue about the special counsel, underlying it fundamentally, is the old quote from the Russian strongman Beria: "Show me the man, and I'll show you the crime." That's how they have tended to work. They appoint a special counsel. They put a target on somebody's back, usually the president, and then they go searching for the crime. You can see that in spades with the Mueller special counsel. Same with prior independent counsels. And I think that's what the court was getting at when they raised that. And they also asked Sauer during his portion of the argument what his position was on the Edwin Meese argument that the Smith special counsel status was unconstitutional.
Yeah, Justice Thomas asked that, whether they had raised that below, whether they were raising it with them, that Smith is not properly appointed.
So it's clear that more than one justice on the Supreme Court is concerned about the status of the special counsel, both legally and practically, in that it's fundamentally flawed, in that you're sicking a bulldog after somebody, and he's searching around for crimes, rather than the way it's supposed to work conceptually is you investigate a crime and find out who did it. So you've got that problem, and that then infects their view of presidential immunity, because
Right. I took that. Did you take it this way? I took all that whole discussion from Kavanaugh to mean that he's totally on board with the immunity. Like, he's not going to go the other way.
yes, I agree 100%.
You know, a subtext to this that nobody mentioned, but I've heard discussed in the past, and I know it goes through their heads. But you know what comes along, because this was a topic of mostly about the independent counsel, but has followed along with a couple of special counsels as well, is, you know, once they're created, there's no break on them.
Right.
Any break on them becomes a political liability for the entity or party or person trying to apply the break. It's like they get as much money.
And now you're interfering and obstructing the investigation.
They
Right.
get as much money as they want. They get as much staffing as they want. They get as much time as they want. You know, any kind of limits in those three aspects become, you know, political interference.
Right.
And so they become a self-perpetuating. I mean, how long did Lawrence Welsh go on?
Well,
Right. Well, and you just I want to pick up on something King said that I think got to the heart of it, which is when King said, "You've the history has been to appoint bulldogs to these positions." So now we've gotten rid of the independent counsel law per se, and we now go with special counsels, which is what technically Smith is. But the notion is that it would be too political.
The president still can't fire him.
It would be too political if Merrick Garland was to make the decision on whether or not Trump was to be prosecuted. So we'll turn it over to somebody who's independent and neutral. And so who do they get? They get Jack Smith, who's a bulldog prosecutor and has never met a crime that he couldn't prosecute,
right,
or at least a perceived crime that he couldn't prosecute. And then they say, "Oh my goodness, we had nothing to do with it. Our hands are off it because it is it's the decision of the special counsel. Merrick Garland and Joe Biden have not a damn thing to do with it."
right.
And this is unmitigated, in case you haven't guessed my view of it, unmitigated horseshit.
Well, the number one example of this was Ken Starr investigating Bill Clinton. He was appointed and started an investigation into an old, almost stale Arkansas real estate deal.
Real estate deal.
And
Yeah.
by the time it ended, he was trying to prosecute Clinton for lying about sexual affairs with Monica Lewinsky in the White House, in the Oval Office. it just expanded and expanded and went on and on and on, and ended up nowhere
Right.
near
And
where it
regardless of
started.
what you think about any of that, that's the way it always goes. It always just goes in that same direction. Right. Well, this brings me to the next topic, which is the quote unquote safeguards. So Dreeben was arguing there's all these layers of protection that are going to prevent rogue prosecutors from prosecuting the former president. And I tell you what, my jaw dropped, and I thought, what, four indictments aren't enough for you to understand that that's nonsense, complete nonsense? And then Arizona dropped one, what, the same day or the next day also. Now, fortunately, the former president is not literally indicted in that case. He's an unindicted co-conspirator, but still. The Court of Appeals also hit on this silliness, I think it is, of saying that there's all these structural safeguards that would protect a former president from being improperly prosecuted. So a bunch of the justices did have questions about this. So let's talk about those. So one was the grand jury. I think it was Roberts, wasn't it, asking this? How much protection is that? Or was it
Yes,
Alito?
Alito,
Yeah.
and this was Alito pushing Roberts out of the way,
Yeah.
saying, "Hold my beer."
Right.
Before Gorsuch stepped up, and then
Right,
Gorsuch,
right. Right. Gorsuch says, hold my shot. Right. Oh, that made Steve laugh, you guys. So yeah, so Alito's like, okay, yeah, that whole grand jury. Remember that ham sandwich comment that all lawyers are taught? You could indict the ham sandwich, and then he literally asks Dreeben, "Do you know of any cases where a prosecutor did not want to prosecute, and the grand jury did it anyway?" And Dreeben was silent for a moment.
the opposite, the opposite.
Oh, where yes, we're sorry, where the prosecutors wanted to prosecute and the grand jury did not want to. And Dreeben was silent for a moment, and finally he said, "There are such cases." And Alito snapped back, "Yeah, there's an eclipse once in a while too."
I have to say, I was an assistant U.S. attorney for 10 years, and I did a tour in the grand jury section, which is in D.C. What you do tours through the various sections. And the old saw that a prosecutor could indict a ham sandwich is absolutely true. The prosecutor controls absolutely what evidence is presented to the grand jury. The prosecutor controls how you instruct the grand jury on what the evidence and the potential offenses are. And so the notion that the grand jury is an independent check on whether someone gets indicted or not is a fantasy.
I know of one case where that happened. It was not a case I handled, but I know of one person who sat on a grand jury and they did not return an indictment, even though the prosecutors begged them to. And it was because there was a retired judge in sitting as a citizen in the grand jury. And he was basically telling the other grand jurors all the reasons why what the prosecutors were trying to do was not correct. That's how bad it is.
Well, okay, so 31 in 32 years doing this work, 21 years as a prosecutor, I know of one case,
Right.
and it's an infamous case that if you're old enough, you will remember it. It's the infamous kangaroo rat case from the Central
Oh,
Valley of California, where one of my colleagues in the office wanted to indict a immigrant farmer for plowing a section of his field that Fish and Game had said was the habitat of a protected species called the kangaroo rat, and he plowed the field anyway. And she wanted to indict him for misdemeanor violations of, Endangered Species Act, and the grand jury said no. That's how ridiculous it has to be to
right.
get no true. They call it getting no true build.
Right. So Alito didn't seem too impressed by this idea that the grand jury was going to protect the former president.
Well,
But
his question was mocking.
yes,
He was mocking.
he was mocking.
That comes out of the appeals court decision. Just
Right.
like just like the chief justice tore it in half, you
Right.
know, with the tautology. He's coming along saying, and we have this justification as rationalization by the appeals court about all these, you know, guardrails that that the special counsel's office seemed to put some faith behind, and he's saying this is stupid.
Right. Who are we kidding here? The next one was the judgment and discretion of prosecutors. And I mean, again, I just laughed. Are you kidding me? And I was astonished to hear Chief Justice John Roberts articulating the position that maybe we can't rely on the good judgment of prosecutors so much anymore.
Well, we've talked before that the Supreme Court over the last 10 years has issued, maybe more than 10 years, has issued a series of decisions where they've cut back on prosecutorial powers to use broad statutes against public officials because they have concluded, I think, and correctly, that prosecutors' discretion and judgment is not to be trusted.
At least not with respect to public officials. And I think it's because it becomes political, subconsciously, maybe even. King, what were you going to say? I saw you.
Wait.
What?
What section of the criminal division did Jack Smith head up?
Oh, public integrity, I'm pretty sure. Yeah, right. And I dealt with them a lot in my career because a lot of my clients were government employees or public officials. I represented a few, not super high profile, but people who had important positions and ambassadors and a few higher level government executives, employees. And, public integrity was awful. That no judgment, what defense lawyers call true believers. Prosecutors who are true believers are dangerous because they don't see the guardrails, much less observe them. So
they're pikers compared to environment, natural resources, and civil
absolutely.
rights.
Steve will laugh all day about that. He had a case once where they prosecuted this poor fool over an orchid. This idiot brought an orchid to be typed.
No, the issue was not whether this idiot had brought an orchid. He brought an orchid from South America to be that was a new
Typed by a
species,
botanical.
and brought it into Florida to a botanical garden to be typed and identified as a new species. So the issue is not whether this guy who actually imported it illegally was to be prosecuted, but whether the person at the Florida Botanical Garden who typed it was to be prosecuted.
Yeah.
And ENRD said, "Oh yes, let's prosecute this person."
Right. ENRD is the Environmental Division at Justice. They wanted to prosecute the garden.
Not only wanted to, they did.
They did.
There was a plea in that case.
Right. This is how insane they are. So the two sections that are there's three sections of justice that are just awful. They're just awful. And they are public integrity, national security, and environmental. They're just awful. There's no judgment whatsoever.
You left out Civil Rights Division.
Well, I never had to deal with them, so I will say they don't usually bring very many criminal cases.
I've dealt with the environmental section not once but twice in my career, and both times were crazy.
Yeah. Right. It's like normal rules don't even cross their minds. And it's really bad because whenever, as a defense lawyer, you have a case like that and one of the special sections at justice is involved, they're always paired up with a line prosecutor. Line, Line. So this is a regular assistant who's in the office where the case is being brought, and the person from the special section, NatSec or environmental or public integrity or civil rights, they have the expertise in those kinds of prosecutions. But they
or so they say.
Yeah, they think they do. They don't bring cases out in the country in the other districts without being paired up with a prosecutor from that district. And what happens invariably as a defense lawyer in those cases is that you end up being in agreement with the prosecutor who's from the office that you deal with all the time, who's a rational human being, on half the shit against this specialist from justice because they're out of their minds.
Well, the point, and I think we're sort of strained from the Supreme Court argument, but the point here is that if all you do as a prosecutor is you're an employee of the Department of Justice, you're an attorney, and you're in environmental division, or you're in the NatSec division, or whatever, is that you look at the narrow range of cases that fall within your purview, and you think, because you think you're doing important stuff, that anything that potentially falls within them is, of course, by God important,
Oh,
and
and the worst
therefore,
crime in the history of ever.
right, and therefore ought to be prosecuted. And the difference with line prosecutors, to whom Leslie was referring, and Bill knows this as well as I, is that if you're actually a prosecutor going into court every day prosecuting a variety of offenses, you have a much better understanding of what's important and what's not important, and what the judge or a jury is going to view as a technicality that is not worthy of criminal prosecution.
Right. So the justices didn't seem too impressed by this argument that we had these, prosecutors who were, using the Constitution to defend the rights of the former president and the other defendants too. And it's interesting because normally it's the liberals who are like, oh, we can't trust these prosecutors, but here it's the conservatives.
Well, I actually think in some ways this is an internalization of the development of the department going back to the Obama administration, which is the department has become overrun by social justice warriors, do-gooders. We're going to improve the country because our vision for what it should be is superior to the yokels.
Right.
And we'll tell you what's right and what's wrong. And we'll show you what's right and what's wrong.
Yeah. No, it's a problem. It's a definite problem. So the last thing I have on here is just
Before you run off,
oh,
there's
Go
another
ahead, King.
side to the coin of what we just talked about. Because Dreeben, in his litany of things that kind of suppress
His structural layers of
layers
protection.
of protection,
Yeah.
he listed lawyers in the DOJ.
Oh yeah, I have that as another
Okay,
topic.
but it's
Hold on to that
related. On
thought.
the one hand,
Yeah,
he's
it
saying
is. It
trust
is.
the
I agree. Yeah.
prosecutors, and on the other hand, he's saying, oh, and by the way, the president has the advice of that same organization, that same bureaucracy, that he can rely on.
Right, exactly. So we're going to get to that. Hold that thought. So the last thing I have on this subtopic is about the state prosecutions. And Justice Barrett kind of hammered this. So she wanted to talk to Dreeben about these layers of protection, right? And whether or not immunity would protect the president in the state courts. And he conceded that if there was immunity, it would protect former presidents in the state courts, which of course it would, because federal law is supreme. So, but she seemed a little more dubious about whether that was going to work in state courts, where a lot of these structural protections he's talking about are not going to even be there. What do you guys think of this?
I thought he had no answer for that question.
Exactly.
And that question came up. I was listening to Hugh Hewitt's show yesterday, and he started with that. And he said, this argument went 2 hours and 40 minutes, and she brought that up at 2:28.
Right.
Almost like she was laying in the weeds with it until right at the end. It's like, okay, we've sussed out the complications of a federal prosecution. Let's say that he doesn't have immunity. What's the implications for state exposure?
Right.
These procedural safeguards don't apply there, and if he doesn't have immunity there, and I think she made reference to hundreds of potential. She made some numerical reference to all the various jurisdictions that could,
all these prosecutors all over the country.
Set upon a president.
The procedural protections. I agree with you on your point, Ship. But the procedural protections technically are the same at the state and federal level, which is that in order to indict somebody, you have to go to a grand jury and establish probable cause. And you've got the professionalism of the prosecutor as a safeguard. But what her question laid bare was that if you've got Alvin Bragg and Fannie Willis as prosecutors,
that ain't gonna do you no good.
That's an empty protection.
Leslie,
correct, and I think hold on, King. there's two key issues there, Steve. One is not every state has grand jury. Some states have done away with it. California has prosecutorial charging. There are no grand juries in California. It's just up to the elected DA or his appointees to sign charging documents. That's how charges get filed in California. And the second thing is, contrary to the federal level, you have people campaigning on a promise to do certain things. So
Right.
it becomes overtly partisan.
It occurs to me that don't we know two prosecutors who did that? Aren't they Bragg and Willis?
Three,
Gee,
throw in
yeah,
Letitia
and
James too,
Letitia James too.
even though it's a
Right,
civil case.
right. So we're shocked and amazed that those are the jurisdictions where these cases are then, right? But I agree with you, Ship. I mean, he had fuck all to say about that. So Dreeben, I mean.
He did say one thing. I don't know if y'all caught this. I don't know if he got the whole phrase out of his mouth, but his instinct, and it came out of his mouth. He said supremacy clause.
Yes, he did. You're right.
And
He did.
which doesn't work without immunity.
Right, exactly. I know. So I was like, oh, I bet you want to jerk that word back because that was only going to work if the president has immunity. Yeah, I know. I did notice that. You're right.
Well, it works if there's an as-applied analysis,
Oh,
as
yeah,
Davina
right.
would say.
Yeah, those state court judges are going to be all over that as applied
You
Article
know, they're
2
they're they're, they're going to say,
challenge.
"Oh no, we don't think it's there. Go ahead, prosecute the president,
Yeah.
make him stand trial,
Oh, God.
make him get convicted, and then make him appeal it through the state courts,
I can
and
just see
and then after he's gone through the entire state court system, then he gets a shot at the Supreme Court."
I could just see myself raising that argument in circuit court in Virginia. I just can
It,
tell you how well that's going to work.
and somewhere, and this was near the end. This was like the last 10 minutes, and
God,
somewhere in
yeah.
there, he made a concession. I can't exactly his words, but he made a concession that the the procedural mechanisms at the state court level might prove to be complicated, but that's not a problem for this case.
Right, right. Of course not. He's totally missing Gorsuch's point that they're writing a decision for the ages.
Well, here I want to jump in here and make a point, which is, and this is something lawyers know instinctively, but I think needs to be spelled out. The courts have said that the whole point of immunity is that it is a privilege not to stand trial in the first place. The whole point of it is that you don't have to stand trial, and then after you're convicted, if you're convicted, raise it on appeal. You don't get tried in the first place. And the courts have said this is incredibly important, and that's the fundamental reason behind having immunity. And that's why they've imposed that.
For some government actors.
Right, for some government actors in some contexts. So here, for Dreeben to stand up and basically say, "Well, we can deal with this after after they're convicted," is cutting completely against the grain of all of these decisions into something that, if you're a justice on the Supreme Court, I think is going to give you a extreme pause.
So I think he might have lost Amy Coney Barrett on that point, but then the next point I want to bring up, I think might actually push her farther to the right. Because I agree with you, Ship. She sort of seemed like a constituency of one to me. It looked to me like the liberals were all in a block, Kagan, Sotomayor, and Ketanji Brown Jackson. And it appears to me that Thomas, Gorsuch, Alito, and Kavanaugh for sure, and maybe even Roberts, although maybe not. But those four are over on the other side. So you've got Roberts and Amy Coney Barrett kind of more in the middle. But I wonder if he didn't push Amy too far with this next issue, which is, okay, you guys. So one of the issues is whether the president could be prosecuted for official conduct. But the special counsel's office is arguing that even if the president could not be prosecuted for certain official conduct based on the way that the Supremes rule on it, they still think they should be able to use that official conduct as evidence in the case to establish intent or motive for the conduct that they are going to be allowed to prosecute. And therefore, they want basically to put it all in and just have the judge instruct the jury with instructions that you can't use this part to convict him directly, but you can use it to evaluate his intent and his mental state. And when he told her that, there was a lot of silence from Justice Barrett.
Yeah, there seemed to be, she had engaged him just before that
Yep.
on the issue of whether or not, there was some kind of form of public authority defense, which is normally a defense at trial,
Right.
that could be engaged in pre-trial with the judge making the decision rather than a jury. And then they had a back and forth on whether it should be a jury question or a bench trial. So this is when she was kind of a court of one. She was the only one that seemed to be going down this road. And then the point you raise is sort of they went around the bend on the issue you're raising about, well, let's assume that there is, or I'm characterizing this, let's assume there is some form of immunity. What do you do with that? And that's when Dreven basically said, well, it's practically it's of no consequence because we're still going to use the evidence of the immune conduct with a jury instruction.
Right. And she just, there was silence from her, which I interpreted to be like, well, that's not what I thought you were going to say.
Right. Right, but it kind of it goes to sort of the practical realities that
Yes.
Gorsuch was getting at. Is
Exactly.
let's put this in practice. Let's take it out of the abstract about defining these various categories and say, okay, once we've defined them, what do we do with them?
Right. I think he might have lost her there, Dreven.
Yeah, because he's essentially saying that the fact of immunity will play no real outcome or no real role in the outcome of the case.
Right.
Because we're still putting in all the bad conduct in. Even if it's immune, it's still coming in, at least by their
according to them. Right. That's not normally how it works, actually. But there are cases that say,
Well, let's talk about what Roberts said. Roberts made the point that in terms of bribery, the whole notion of bribery is that you take money or something of value in return for an official action. So the evidence of the official action is necessarily part of the proof of the offense. And Roberts said, how in essence,
how can we separate that?
How do we separate that?
I think he asked that of Sauer, I believe, didn't he?
Yes, he
and
did.
I think Sauer
Yes.
gave him the wrong answer.
Correct, yeah.
Well, I thought he gave him the better answer, which is the court has always said that bribery is a private act, not an official one. So, but of course, you have to put in as a fact that what it is you're getting and what you're giving up.
It's
to me, that's
where Sauer went off the rails, I thought, by not articulating that the crime of bribery involves a quid pro quo, an agreement, and the agreement itself is the crime plus the payment. You don't need to put on evidence of what happened after he got the money.
Right. Although traditionally a prosecutor would put on evidence of what that was.
And you're entitled to put on evidence of what that was. As a former prosecutor, I would jump up and down saying, you're entitled to put on evidence that not only did he get the money, but then he delivered in terms of the official action.
But but Sauer was trying to say you couldn't even put on evidence of what the other side of the agreement was.
I didn't understand him to say that thing. I thought he went. Yeah, I thought he went the other way. He was telling Roberts that bribery is private. It's private conduct. So even though you have to show what the official act was for the quo, that doesn't change the nature of bribery as a private action. So you could prosecute that, and obviously you'd put on that proof. I think that's what he meant.
I posit here that the issue sort of turns on the offense at issue. In bribery, Congress has said that if you do an official act in return for money or a thing of value, you have violated the criminal law. And that applies even to the president. So, therefore, evidence that the official act can come in. There are other offenses in that same section of the U.S. Code that deal with, for example, conflict of interest or gratuities or stuff like that, where they've generally exempted the president from them. But if Congress were to say, if you take an action, an official action as president, and don't disclose that you have a conflict of interest because your wife, daughter,
Child,
son
right.
will benefit from this, my own view is Congress could do that because the president's then on notice that he or she, if you do that, you are not committing an official act, you're committing a criminal offense. But other than that, I don't think that they can, evidence of the official act should be admissible.
Right. So
Yeah, here's how this plays out. From a practical standpoint in a trial, what Smith wants to do is he wants to prove up this conspiratorial narrative, which has, as Dreeben referred to it, I think he referred to it, as an integrated scheme with several moving parts, all of which sort of explain each other or explain how the scheme developed over time. And some of those moving parts are private, and some of those moving parts are official acts. And they are all necessary to fully understand the scope and purpose of the scheme, so they think they should be able to bring them all in. The question is, if there are official acts for which there is some form of presidential immunity recognized, does the immunity preclude the use of them in proving this integrated scheme?
what's left over?
The
Right.
bribery example is sort of a hard one because it's just a quid pro quo. You have two sides of a transaction, and it's like only knowing one side of the conversation, you can't really understand what the conversation was about. It's a different factual scenario when you're trying to prove a series of events over a period of time with multiple actors, and you're
Well, and
dividing them
he
between
said
private
he
and
wanted,
official.
and he said he wanted to use that evidence to prove motive and intent. Well, they don't have to prove motive, but to prove intent or purpose.
Was it
So
you
basically,
mentioned that? Did you catch that? Did you? There was an exchange when they were talking about the president, the motives behind presidential action should not be the subject of inquiry.
right.
And there's and I can't remember exactly what Dreeben said something about. Well, it would be to prove intent, and I think it was Gorsuch said
Right.
to him, "Motive is intent, intent is motive." It's like
Right.
they're the same
Right.
thing.
Right. You can argue that either way all day long, and people do. Right. So yeah. So it's basically what the special counsel wants to do is, even if the Supreme Court says you can't prosecute him for A, B, and C, but we'll let you do D and E, they still want to use A, B, and C to prove intent for D and E. And when Dreeben dropped that on them, Amy Coney Barrett was the one who was asking questions at the time. Like, she just seemed shocked by that.
Well, he actually explained it this way. You remember Sauer argued that anything related to involving the president's official acts should be expunged from the indictment and not
Right.
used as evidence. And but there were plenty of private acts alleged in this indictment that they could pursue. And somebody asked Dreeben, what about that? What if you two agreed on what was private and what was not? Could you go forward with the private acts only? He said no. He said, I need.
No. He said the opposite. That was Ketanji Jackson asking right at the end, and he
Yeah.
was backstroking from where he was with Barrett. He was backstroking that and said, oh, yes, we could go forward on that alone. But then they're going to try to move in the other evidence, not as
And he was
criminal
backstroking
conduct.
on that because what he had told Amy went over like a
Exactly.
fucking lead balloon. Right.
Exactly.
Right. Yeah. Okay. So the next topic I have is about this case called Blassingame, which is spelled Blassingame. And there was quite a bit of discussion about this case in the argument, principally with Justice Gorsuch, but others too. This is a case from the D.C. Circuit written by the chief there, Sri Srinivasan, who is a very, very smart judge. And this case is, I think it's a Trump case, and it has to do with whether or not it's a civil
So
case. It's a civil
it, it,
case.
it involves a couple of members of Congress and multiple Capitol Police officers suing Trump and a bunch of others for damages connected to January 6th.
Right, exactly. And so the question is a similar kind of issue, like what is up for grabs and what isn't, because members of Congress, government officials, they have certain kinds of immunity or certain kinds of protections. And just Judge Srinivasan has drawn this distinction between a politician seeking office and a politician holding office. And so the idea is that the holder of a public office has certain powers, rights, whatever you want to call them, responsibilities, and that's sort of on one side of the line. And but an office seeker, someone who's still a private citizen, not yet a public official, that those same actions by an office seeker versus an office holder are private in character rather than public in character. And Justice Gorsuch asked Dreeben if that was the analysis that they would thought was the correct. Well, it might have been Sauer. I may be remembering it wrong.
So
Ship, do you know if that was the correct way to sort of analyze the conduct in President Trump's case? That looks like him more acting like a candidate, even though he's an incumbent in office. So, what do we make of this distinction between office holder and office seeker? Do we think that that's right?
I think okay. So I got to confess, I haven't read the case, so I
Yeah,
don't know exactly how the rationale came out. But I remember. I think that was of Sauer initially, and I think they later revisited it with Dreeben. But I think it was
Yeah.
Sauer initially, and he agreed, which I thought was a mistake, and we'll get to a
He's
couple of
sour.
his mistakes.
He's
Yeah,
sour. Yeah.
but emphasizing that he thought that is it Judge Katsas, the Katsas concurrence
Yes.
was a necessary component of adopting Blassingame. I don't know what Katsas wrote.
So Katz's concurrence is in the district court's decision below, and if I remember it right, Katz's is basically saying more or less Judge Srinivasan got it right at Blassingame, and this is what we should be doing.
yeah.
Um, Go ahead, Kate.
No, I think Katsas was part of the
It's part
panel.
of, he was part of the panel, I
Yeah.
believe, and
Right.
Sauer brought that up. He said they asked him, "How do we determine what is private act versus official act?"
Official.
And he said, "Use Blassingame. That analysis we agree with." And you read that opinion; it's very well organized, very precise as to how you determine what acts by the president are private. And came to,
Based on this distinction
yeah,
between office seeker and office
right. And
holder.
and and there it did not finally decide as to all the acts in question. It said we're going to have to send this back to the district court for further development of the facts. This was a civil case. It was decided on motion to dismiss, which means you have to accept the plaintiff's allegations as true. So they couldn't decide it on the face of that pleading. They had to send it back for further factual development. And they kind of gave some guidelines as to what to look for and what factors to apply. It was very well written and very well reasoned, I
I,
thought.
yeah, I think is that I may be confused with a different civil case. Is that I think Trump asserted presidential immunity, and that was denied, and then they took that up, and they sent it back saying, well, and that's where it
That's where
depends on the
Srinivasan is
nature of
saying
the
it
conduct,
depends.
right?
Exactly. Right.
And then so they sent it back for fact finding as to the nature of the conduct with guidelines, and essentially, I haven't read it, but as I sort of tried to decipher it, what I think Sauer was saying is, look, this court should send the criminal case back to Chifkin with a similar framework for deciding between conduct.
Right. How to parse what's private, which everybody agrees can be prosecuted, and what's official, which is the debate about can it be prosecuted, and if so, how much.
Right, because the fundamental difference is that in this case we're now discussing Blasingame, there was an understanding based on the Supreme Court's decision in Nixon v. Fitzgerald that the president does have immunity for official acts. And so it was drawing the lines for how you distinguish between official and private acts. Here, the
whole question is, does Nixon v. Fitzgerald apply, that
right.
type analysis apply in the first place?
Right.
Yeah. So, and this then leads me to the next topic, because these two are linked. At the beginning of the argument, Justice Thomas asked Sauer, where does the presidential immunity that you're talking about come from? Sauer said it was the vesting clause, which is the clause that vests in the president all of the power of the executive office. Basically, the courts have said, if you have XYZ powers under the Constitution, then that means that of necessity, you have all of the tools at your disposal, or all of the legal positions at your disposal to carry out those responsibilities. So that makes sense from a constitutional analysis. Thomas then asked, okay, but what's the scope of official? What's in and what's out? Sauer's argument is that the criminal should look the same as the civil, that it should be what the Supreme Court said in Nixon v. Fitzgerald, where they said anything within the outer perimeter of the scope of the president's responsibilities should make him immune. And of course, the special counsel is arguing that it's much more narrow than that. Now, I think that we are putting ourselves in a big problem by adopting this paradigm for it and lumping or adding Blasingame onto it as well. It seems to me, but the court was not talking about this at all. They seem to just accept that Blasingame is kind of the right way to look at it, which, on the one level, Sri Srinivasan is a super smart guy, and he's the chief of the Court of Appeals, so, he's got a lot of gravitas on his side. But I really worry that if we make the distinction between private and official, that's not really right. That where the line should be is the difference between private and public, and that public means both official and campaigning. Because if we draw the line with campaigning is private, which Sauer conceded that campaign activity was private, but I really think maybe we want campaign activity to be official, or to use my word, public, because otherwise it runs you right into the problems that Justice Gorsuch then hammered them on, which is, don't you end up just having to look then at what the person's motivation was rather than what they actually did? And that does seem to be where Blasingame comes down on it. It's that you look at whether the exact same conduct by a candidate who's an office seeker is problematic, but the exact same conduct by the person who's an office holder is not. That does not seem right to me. What do you guys think of this whole issue about what's in and what's out?
I read Blasingame a little differently. Blasingame, the decision took an objective view in context. It emphasized you can't take somebody's conduct out of context of what was going on and what the objective reason for doing it is. It did not delve down into subjective intent. It looked at things like, here's a speech the president gave. Who was it addressed to? What what was the message? What was the purpose of the speech? Is it a private aim that he's trying to convey, elect me, or is it a more public uh, position? And the one he really, the opinion took off on was I forget the name of the speech, but concluded that it sounded like a president using the bully pulpit to put his official message out to the country. Uh, that's the kind of analysis that case did.
Well, I agree, but what my point is that if you're going to say the exact same conduct is okay for office holders, but not okay for office seekers, then aren't you necessarily, when you're trying to decide if the office seeker is doing something criminal, then aren't you going to just have to look at what their intent was, what their purpose is? And isn't that just going to take us into, if you don't agree with their political views, it's going to look like bad intent to you? And if you do agree, it doesn't? Like, I'm not comfortable with this distinction between if you're in office or not in office.
Yeah, I don't like it either, and I thought Gorsuch sort of went down this road quite a bit by, or maybe it was Alito, saying, an office, a first-term president, everything he does has some consideration of getting reelected.
Right. In
It,
that situation, he's both an office seeker and an office holder. Now what are you going to
right.
do?
So and that's a point I've made on this issue in the past. I think less than convincingly, but I'll stick with it. Which is, I mean, he's president, you know, 24/7, 365. He's
And
never
candidate.
not president.
But
Yeah.
He's never exclusively a candidate like somebody who's not in office. He's always president. Everything he does has some aspect of, you know, presidential responsibility or consequence.
but the Blasingame case, Ship, steered away from that. It did not rely on the fact that, well, President did X because he wanted to get reelected. That was not a part. In fact, the decision expressly rejects that kind of an analysis.
Right.
Now, I think this is probably something you've got next on your list, but I thought wading into this subject matter instead of looking for a way to deflect and take an off ramp was the biggest error that Sauer made, and I communicated
Right.
this to you, and
Yeah.
you indicated Steve agreed, and that was when he allowed himself to get drawn into a question and answer about whether certain allegations reflected in the indictment were private or official, and at least three times that I recall, he conceded that's private. It's
Right.
like,
And I wasn't so much bothered by the some of those specific allegations, but he conceded that all campaign activity is private. And I just think that cannot be right. That can't be right. And if that is right, then the law is wrong. We need to change that to say it's not private versus official, it's private versus public, because you just are setting yourself up for political prosecutions if that's what you're going to say the test is.
well, and as a consequence, here's what he's done, though, as a more practical consequence, thinking through this as, trial practitioner. He's, in effect, now done Judge Chutkan's job on three subjects.
Partly for her, right? I
Okay,
agree.
so he's conceded a factual, um, uh, uh, made a factual concession on those three specific allegations as framed in the indictment. But he is also now given a template against which she can measure other allegations and say, well, it's of the same character.
Right.
And therefore, on the same, on a parity of reasoning with regard to the three concessions, these are also private as well.
But they
And
weren't truly private. They were campaign on top of what you're saying, right? I wouldn't have
well,
conceded those were private at all.
right,
Not at all.
and the correct answer here, which is a hobby horse I've been on for a while now, is we don't agree with the characterization of the
Correct.
events as described.
Right.
The events themselves might not be factually contested, but they are written in a pejorative and conclusory manner.
Right. But you only have to worry about that if you're saying campaign actions are private. If campaign actions are public, then you don't have to worry about, well, their characterization of why you did it is different from your characterization of why you did it. It wouldn't make any difference.
But if the issue is not are they public, the issue is are they within the uh, uh, outer parameters of the official acts of the president.
Right, I
So
know.
if this president was serving his second term, he would not be campaigning.
Well, he might be campaigning for his vice president, though, as Ronald
He
Reagan
doesn't
did.
have to. It's not part of his job.
Right. But see, this is where I think that fundamentally we have a problem with the way we have set up this question, because we're ignoring the reality that all of our public officials are also candidates, and that we know that candidates use their offices to stay in office, and we're all fine with that because there isn't any other alternative. Right? This is a factor, an aspect of representative democracy that just is. To me, the line should be, if you engage in private action to try to stay in office, that's a problem. If you engage in public action to stay in office, it's not. So, like, you can't murder your way into the office, right? You can't extort your way into the office. You can't do treason to stay in office. But you can use the powers of your office to stay in office. But unfortunately, King, you're right. The legal structure that we have is not that. The legal structure is immunity for official acts. So that forces the justices into this question of, as because they were the ones that were making Sauer answer this. Is it private? Is it official? Right? He didn't volunteer to do that. But he can't tell, when Amy starts asking him that, and Elena Kagan starts asking him that, he can't say, I'm not going to answer that question. He's stuck.
He did answer.
Yeah,
He did answer the question, like the $64,000 question in Smith's case, whether it's public or official, and that has to do with the quote fake electors and he
Right.
said
Yeah, he was
he
strong
was
on
strong
that.
on. He
Yeah,
said
he
that's
was.
official, and
Right. They seem shocked by that.
Blassingame
Yeah.
suggests it is too.
Yeah. Right, because all these liberal legal people who want to say, "Oh, the president doesn't have any role in the elections and the electors and all of that," that is wrong. And he gave a very good factual answer to that. And I had not known about this historically, that President Grant had sent what the National Guard to one of the states to ensure that the certificates for the Republican Party could be properly brought to Washington, properly certified and brought to Washington in the Reconstruction era. So if President Grant thought he had the authority to do that, to make sure that the process worked out properly, how are we saying that the current president doesn't have any role in that? That can't be right.
A little history that had to do with Reconstruction government in Louisiana, which was primarily black run, but of course you had the former Confederate uh, politicians who felt differently, and you had
Right.
a internal battle in the state as to which electors were properly uh, elected in the election.
Right. Yeah. So I agree with you, Chip. It's sort of like, one man's freedom fighter is another man's, treasonous rebel. So, but this is why I really think bigger picture, the paradigm we've set up of private versus official is kind of problematic. So, um, this then takes me to my next topic, which is the SEAL Team 6 hypo, which I did not think they would go there, but they did. Um, and Elena Kagan went even farther, asking about a coup, which I was shocked by that. But if the president were to order a coup. So, but Justice Alito defended the SEAL team folks and said, this idea that a president could order SEAL Team 6 to murder his rival assumes that these honorable officers are going to carry out that order, which they undoubtedly are not, because they're going to be punished under the UCMJ for carrying out an unlawful order. So why are we using this ridiculous hypothetical? But it's sort of it focuses on a point that Justice Kagan wanted to talk about, Justice Gorsuch wanted to talk about, Justice Sotomayor wanted to talk about, which is, what if you're doing something that technically you have the power to do, but you have a bad motive or a bad purpose for doing it? Should that then make it outside the scope of immunity and prosecutable? So I want to debate this, but Steve has an interesting take on the whole SEAL Team 6 hypothetical that I wanted to ask him to talk about.
Well, the SEAL Team 6 hypothetical assumes that you got a bad motive and that presidential ordering of a murder could never be official. And my response to that is to raise the movie and the failsafe, where the whole premise is that the United States mistakenly sends a nuclear missile heading toward Moscow, discovers it, can't call the missile back, and the president contacts Moscow and says, look, this is an accident. And in order to convince Moscow that it's sincere and not to retaliate with all-out nuclear destruction, orders the U.S. to drop a nuclear missile on New York City and wipe out New York City.
In order to save the rest of the nation.
Right. So this is Hollywood, obviously, but the point is that there are scenarios in which the president can order murder
that we might well think were within his official duties.
Right.
Or a court could conclude that.
Now, are we going to let Alvin brag after the fact? Not that, Alvin Bragg would have been wiped out along with the entire population of New York City. But are we going to let Alvin Bragg after the fact say that's mass murder and I'm going to indict the president for mass murder?
Right. Fannie Willis will do so in Atlanta. So, right. But it's kind of, I've objected to this SEAL Team 6 hypothetical all along. It's really talking about misuse of government office rather than use of your government office. And it seems to me that murder is still a private act, whether you're using, military officers to try to accomplish it or attempt it or not. But yeah, I like Steve's observation that, the left is using that to say, oh, well, that could never be justified. But is that really right? And that's what Sauer was arguing. When Elena Kagan asked him, well, what if the president ordered a coup? She didn't like his answer because his answer was, well, I need more facts. It would depend on exactly what the facts are. Because coup is a loaded word. He wanted to know, well, what are you saying that the president actually is doing? What did you guys think of those issues?
Well, I don't think that a president can order a coup because a coup
Right.
is the military taking over the civilian.
Right, I know. Right.
Which sort of makes you scratch your head about Elena Kagan asking a dumb question.
Well, also the whole SEAL Team 6 thing, which was posited originally by Judge Pan, I think, from the Court of Appeals, is sort of like non-military people making these assertions about military matters of which they are entirely ignorant. So there is that aspect to it. But go ahead, Ship.
No, that was it.
Except the murder issue came up in another context, and amazingly, Dreeben agreed or told the court that it couldn't be prosecuted. That was the issue of whether Obama could be prosecuted for droning an American citizen and his son. And
Right.
could he be prosecuted for murder? And
his basic answer was,
no.
well, sometimes the president can order that because...
Yeah, he said he could do that. He couldn't be prosecuted.
Right.
And he...
What I heard him say was that and this is, I wrote a little bit, and I'm going to change it if I'm wrong. What I heard him say was that DOJ has looked at it
Yeah.
and
Right.
has determined that it was not
Yeah.
unlawful homicide.
Right.
And so
OLC.
the question I posed is, I wonder when they did
but
that.
but
Did
Yeah,
they
really.
do that just recently to address this problem?
No, I think they did it before, but I think the whole point is that Dreeben's defense of that was to say, well, no, OLC took a look at this and decided in real time that this was okay for the president to order this murder of of potentially U.S. citizens. And
Steve, specifically, he said they determined there was a public authority defense, which
Right.
I've
Well,
never
yeah,
heard.
but that just simply means, all that means, that's a recognized defense in the federal rules, and all that means is that a person authorized or a person with the authority to authorize law breaking tells you to go ahead and do it.
Right.
Yeah, that's
And
my
and
understanding.
Which is not quite the same
It's not.
thing, is it?
in this
It's
instance, yeah,
it's
and in this instance, the DOJ authorized Obama to take out
well,
the terrorist.
I'm
no,
so
no,
glad that
DOJ
they
didn't authorize Obama. The DOJ said Obama was authorized to say that this murder is appropriate.
is lawful.
And
Right.
if Obama is authorized to say it, why isn't Donald Trump or any other president authorized to say it's lawful?
Well, that goes to the point that I can't remember which one raised it, was, because Dreeben was saying, well, the the president has the benefit of the advice of the finest lawyers
Yes.
in the land, of the Department of
Right.
Justice, and if they tell him he can do something, that's an absolute bar to prosecution. And then,
Right.
I don't know, I think this might have been Gorsuch. He says, well, that just sort of encourages the president to name an attorney general who tells him he can do whatever he wants.
Right. I was waiting to see if he was going to say, like his wingman, but he didn't. So, um, but yeah. So, and King, you alluded to that earlier, and I do have it on my list because Dreeben's one of the things Dreeben said was a layer of protection was that the president would have the advice of the best lawyers in the country. So, the Attorney General's office, the Office of Legal Counsel. He didn't say, but he said, and others. He kind of implied it could even be private lawyers, right? And so somehow that would prevent the president from doing things that a prosecutor might later prosecute, or more likely that the fact that the president had gotten advice from a lawyer would stop prosecutors from prosecuting him. And I sat there thinking, isn't aren't the president's lawyers indicted in some of these cases?
his
Right?
his personal lawyers are indicted in
Yeah,
Georgia and
yeah,
listed as unindicted co-conspirators in
yeah.
Prosecutor Smith's case.
Right. Isn't Jeff Clark on trial in Georgia?
Yes,
And he was a DOJ official, so that's not even a personal lawyer.
Right.
Um,
So
but
it's
but
like, oh, you think that's a precaution unless you don't like the advice the lawyers give. How's that a protection?
but this is where there was a little bit of, an unrecognized apples and oranges aspect to this
Yeah.
argument.
The whole
That
argument was like that. I agree with you.
well, a public authority defense is something you put on in your defense case. You're still going to stand trial.
Right. It's not
and and
immunity.
and
Yeah.
then you put on a witness that says, I had the authority to authorize his law breaking because there was a public interest in him doing so. This is the classic informant buying a pound of cocaine from a
Right.
cocaine dealer. That's an unlawful act, but if an FBI agent tells you to go ahead and do it, you've just been authorized to break the law. Um, and
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 he
so
implied it would go to that and also to prosecutorial discretion in the charging
Yeah,
decision.
but
But
but that's a
okay.
trial defense. That's not an
Yeah.
immunity issue, and so they were
Right.
talking about these things almost interchangeably at
Ship,
times.
you're right on the law, but that's not what Dreeben said. He
Yeah.
said he would not be prosecuted because
Right. He was using it more as a prosecutorial discretion function.
Yeah, well, okay, so I mean, I accept that's what you heard, but I heard him say that the president could assert an absolute offense, not that it would bar the charge.
Well, he may have meant or said both, but I still have the question of that doesn't seem to have slowed down these prosecutors, though. Right? This president got advice. That's not it's advice they don't agree with. So, you're back to square one. Now, I did find it interesting, and King, this was your point earlier, that it was not just the justices on the right who seemed concerned about what part does motive play in the analysis. At the beginning of the argument, certainly, Justice Sotomayor seemed to me to be kind of concerned about this also. That really, is that what we really want to base this on?
Yeah, she started down the path of qualified immunity.
Yeah, she did.
But then dropped it, and I'm not sure why. But she seemed to be reaching for a middle ground of some immunity, but not absolute. Will make it qualified, which means for the layman, it means you're immune provided you were in good faith and doing it honestly and didn't have an improper
Right.
motive.
Right. For the absolute immunity, the judge doesn't look at whether you have good faith. It's just you're just immune because it was within the scope of your duties, and we don't really care whether or not you, in good faith, knew that or not. Um, okay. And then for Gorsuch, that led him into this discussion of the pardons. What's the role then of pardons and the president's power to pardon? So the I thought this was a fascinating discussion, and it had two aspects. One is what incentives for pardoning or not pardoning would this kind of thing bring up? And the other was the effect of President Ford's pardon on President Nixon. How does that play into the analysis? So let's talk about that for a minute. So Gorsuch posited that he got Dreeben to agree that the peaceful transfer of power is something that's needed for our democracy to function. Dreeben, of course, agreed with that. Which, to digress here for a second, then somehow led Sonia Sotomayor to think that talking about what was necessary for democracy was somehow up for grabs, and she went on a little rant about that herself later. But Gorsuch wasn't raising that in the abstract. He was making the point, he wanted Dreeben to agree that that was important or necessary for functioning democracy, so that he could then, the very next sentence, ask him, well, then what incentives does that create for presidents pardoning basically themselves or their administration? And aren't you just setting it up to incentivize them to do that? And we've never had to decide as the Supreme Court whether the president can pardon himself or not, or issue sort of blanket pardons for his whole administration. And he asked Dreeben whether he thought the court needed to decide that point in order to decide this case. So what did you guys think of the argument there and Dreeben's responses to that?
Yeah, I thought this was a little bit of this is Gorsuch's way, I think, of teasing out the complications of going down this road.
Right.
That there are this is just pulling on strings of the garment to see what happens. And I don't think there's any right answer to these questions, and there's no answer that solves the riddle. But I think that's the point that Gorsuch is making.
Gorsuch was making the same point that is found in the old story about the lady who claimed that the world was flat and was riding on the back of a turtle, and she was asked, "What's the turtle standing on?" She says, "Well, it's turtles all the way down."
Right.
And Gorsuch was making the point is if there's no immunity, but the president can pardon himself the last day of every presidency in office, he pardons himself. So we have pardon after pardon after pardon after pardon,
Right. And all of his
and
people.
that solves
Yeah.
the problem, doesn't it?
Right. It does, except that Dreeben doesn't like that. But Dreeben's the one that stood there and said the pardon power is one of the powers that the Department of Justice thinks is absolute in the president. The president can pardon, and that's
Right.
the end of it.
Right. So, which shows that Gorsuch is a very smart guy,
Yeah.
and shows that this is a very complicated issue, because if you there's an there was an agreement among all of the parties that the president had certain core powers that can't be intruded on criminally, or by the judicial system, the judiciary. And one of these, if it's not immunity, then do you shift it over into pardon power? It ends up with the same thing, which is that the president is able to say, look, all of the decisions I've made and my administration have made in the pursuit of my policies are not to be criminally prosecuted. Well, that's the basic assumption under which the Constitution was written. And the issue is, how do we enforce it? Do we do it through the pardon power? That would be a very, I'm searching for the right word here. That would be a very raw,
Yeah.
uh,
Political power.
way to do it. The other way to do it is to do it through immunity, which is to say, unless it's a purely private action, we don't want to get into it because the Constitution is such that it's not appropriate to get into it.
Right. So now, Justice Ketanji Brown Jackson asked Sauer, well, what's up? Literally, she said, what's up with the Ford pardon then of Nixon? Like, if people, including the presidents, didn't think they could be prosecuted, then basically why did Ford pardon Nixon? And Sauer gave the sort of superficially correct answer, which is, well, Nixon was being investigated for both his public and his private conduct. And so Ford's pardon just, took that off the table. Whatever there was that Nixon could be prosecuted for, he just put an end to it. And so there's that aspect to it. In thinking about that, it strikes me that the fact that Ford did that kind of kicked all of these issues down the road to now. Like it let another 40 or 50 years go by without having to decide these very difficult, thorny, messy, ugly questions, and just move on. What did you guys? Any more thoughts on this pardon question?
Yeah, the Ford pardon episode in this argument was interesting because I think it was Sauer made the point. I'm not sure, but the point was made that at the time Ford pardoned Nixon, I mean, he made all kinds of enemies. He made everybody mad.
Yeah.
And but in hindsight, many years later, more and more people came to recognize the good it did for the country by
Right.
putting aside the emotional and political crisis we were in. And
And see, that was Kavanaugh
yes,
saying that. That
and so and which speaks to why immunity might be a really good thing. Be-
Also, it aligns with his discussion about the independent counsel statute, right? He's really looking at it saying, you know what, it's bad business to prosecute former presidents. We should probably just not be doing that. King?
I agree. That's the point he was making, and he made it very well. I thought,
Yeah.
and nobody came back at him. Nobody disagreed.
Took issue with that, right? Okay, so there's one more legal issue, and then we're going to get into some political question. Procedural questions, and then we'll talk about okay, so what are they going to do, and what's the opinion going to look like? So we've only got a couple more topics to go. So the last legal issue was this clear statement rule. And so people understand that. So the clear statement rule, they talked about this a lot. It seemed to me that most of the people in the argument talking about it didn't know what it was and didn't understand how it worked. Which is, shouldn't really be the case considering that most of the people in this argument were Supreme Court justices. But the clear statement rule is a principle that mostly OLC has used, but the courts have occasionally used, which basically says if you have a criminal statute that just generally applies to everybody, but someone wants to apply it to the president and say, well, the president's violating this law, the legal analysis goes along the lines of if it's a generally applicable statute, doesn't name the president specifically as being included, also doesn't specifically exclude the president, because there are some offenses that the president is excluded from, like the Hatch Act. And then there are a few offenses that specifically say the president is subject to the offense. But most criminal statutes don't say one way or the other, of course. So this clear statement rule is a way of looking at the law to try to say that when the Congress passes a general criminal statute, if a prosecutor wants to use that against the president, we have to look at whether or not the law, as proposing to be applied, would infringe on the powers of the president and the core functions, whatever we want to call them, of the presidency. And if it seems like the law would apply to the core functions of the president, if it raises a serious constitutional question in that regard, then we will ask the courts, or we will advise that the correct interpretation of the statute is that it does not apply to the president. So it's kind of a way of avoiding a serious constitutional crisis about whether statutes apply to the president or not. So this idea was sort of lurking around, and it was briefed in the briefs. Sauer and the president's lawyers briefed it, to my eye, they briefed it as a reason for explaining why there has to be immunity. That consistent with this principle is what makes it. Immunity would only make sense if you're kind of using this principle with it, or the lack of immunity would not make sense in light of this principle. Now, the special counsel, they tried to say, well, this doesn't have anything to do with this case. I don't know why you're raising this. You raised this below, but not on this motion. You raised it on a different motion. There was an implication, actually, from Justice Kagan, I think it was, that this was maybe a little improper. And Justice Ketanji Brown Jackson asked if they had waived this argument because they didn't raise it below. But I read their briefs as not raising it directly, but rather saying this helps you understand why what we're saying about the immunity makes sense. Okay, so what did you guys think about the debate over this clear statement rule?
Yeah, the objections I heard is it was Judge Jackson who said that why wasn't this forfeited, since it didn't get raised in the appellate court leading to the appellate court's decision. It was raised in a different motion. And then, Dreeben said, in the context of an interlocutory appeal on a issue that is subject to interlocutory appeal, they thought it was improper to introduce arguments that wouldn't have been subject to an interlocutory appeal, in order to piggyback improper issues into an interlocutory appeal on an immunity question. I'm not sure at the end of the day the issue really goes anywhere. I think it leads down some difficult, propositions, such as, well, the president's not, the office of the president isn't named in very many criminal statutes. So if we apply what is really as you said, it's an avoidance statute. It's a method to avoid constitutional confrontations between the legislature's ability to criminalize conduct, and the separation of powers claim made by a president that you can't intrude on my prerogatives. So where those two streams cross, so to speak, the court, in refereeing the dispute between those two other co-equal branches of government, says we're going to narrow Congress's statute, or we're going to adopt a narrow interpretation of Congress's statute, and if they want something else, they can change the wording.
Right. They can say so if they really think this applies to the president, and then force the constitutional issue.
At one point, I understood Justice Barrett to be exploring that concept as
Yes.
a lifeline, so to speak, to avoid deciding immunity. We can.
Yeah. She went down, yeah, she went down a logic tree with Sauer that went along the lines of, okay, you're saying private conduct can be prosecuted. He said yes. You're saying that official conduct can only be prosecuted if it's been impeached and he was convicted first. And he said yes. And then you're also saying that even then it would have to be, he couldn't be prosecuted in a statute that didn't specifically say it applied to the president. And Sauer said yes. And then Justice Kagan picked that up later and was like, well, that doesn't leave very much, does it?
So I would not put that thing to bed yet, because
Yeah.
we may see a concurring opinion saying that in this case, or because of the statutes that are at play, that do not name the president, we can just decide it on this more narrow basis and
Right.
avoid the immunity issue.
Right. Yes. So, and we're going to get to that at the end, because it does seem like some of the justices would like to try not to pick either side's argument and do something else instead. I'm not sure they're going to be able to do that, but we'll see. Okay, then there's one technical data point here I want to make sure I mentioned, because people had asked on Twitter, what is it going to get raised? This question about, King, you already alluded to this, whether the special counsel is properly appointed. And I was shocked, but Justice Thomas raised that question. He asked them directly, did you, are you raising that here? And they said no, they had not raised it yet by the time this motion was coming, had to come up. So it sounds like they do plan to raise it. They have in Florida.
Yeah, he said we've raised it in Florida, so it's on the table, and I doubt that the Supreme Court will get to it now, but it certainly is a factor. The special counsel and the seemingly lack of reins on the special counsel that is historically the case may be a factor in whether to protect the president some way.
So here's my question. Justice Thomas had to know that they weren't raising that in this petition. So why did he ask that question?
Well, the former Attorney General Meese has filed an amicus brief.
Yeah, right.
In which he has asked the Supreme Court to throw the whole case out.
Right, but the amici don't have any basis for asking for relief. So you think Justice Thomas raised that just to highlight it as an issue?
I think he might. So here's a point that I think all of us understand, but everybody else might not. If Justice Thomas sees that as a jurisdictional issue,
right.
In other words, the special counsel does not have lawful authority to appear on behalf of the Department of Justice because of this defect in the appointment, then he will write a concurrence saying, I would order the case below dismissed on the basis the special counsel is not properly appointed, and it's a jurisdictional issue, and we don't have to reach anything else.
So he was asking just to make double damn sure on the record that the former president's lawyers are not raising it, even though he might write about it.
Correct.
Yeah.
Now,
go ahead.
Except the law.
Yeah,
the law is that courts can raise lack of jurisdiction on their own
Exactly.
without
Right,
Exactly.
at any
anytime.
time.
Res
Yeah,
sponte.
anytime. So, and I was shocked and fascinated that Justice Kavanaugh asked him, "Who exactly do you represent?" Because he's on the special counsel's team, right? He doesn't work for the Department of Justice. He's no longer in the Solicitor General's office. And
No, no,
Kavanaugh
no,
asked,
that's not true. He is now special counsel, or he is special counsel to the special counsel. He is a Department of Justice employee temporarily.
right. So if I posited that way, I apologize. My point is he's with the special counsel. He's not at main justice, right?
Correct. Correct.
Right. And he's not in the Solicitor General's office. He used to be, but he's not now.
He he was Elizabeth Prelogar's boss.
Right,
Correct.
exactly. So normally only the SG can appear in this court on behalf of the United States, right?
That's my first point in my new Substack article. Is I
Right.
expected that the Solicitor General would appear
Right.
because my understanding is only the Solicitor General appears on behalf of the Department of Justice Supreme Court. I
I
could be
thought so
wrong.
too. Yeah.
Here he did to address that issue. He said he was asked specifically. I forget which justice Kavanaugh
Kavanaugh.
did.
Kavanaugh
Asked him
asked.
whether
Yeah.
he conferred with the Solicitor General, and he said he did.
Yeah, Kavanaugh was very sharp there. He asked him, "Who exactly do you represent?" Because Dreeben had started saying, "It's the DOJ's position." And Kavanaugh picked up on that. And he was like, "Wait a minute. Who exactly are you speaking on behalf of?" Because I think they thought, or at least Kavanaugh did, that he was only speaking on behalf of the special counsel's office. Turns out he's speaking on behalf of DOJ/Solicitor General's office. And then Kavanaugh asked him, "Who have you consulted with? The White House, the Attorney General?" But Dreeben denied all that. He said he'd only spoken with the solicitor. But that was fascinating to me because I thought, wait a minute. I assumed that the Solicitor General had deputized him in some way, but there's nothing like that on the docket, and they didn't say that in the argument. But Kavanaugh was so sharp about it. Maybe they thought they were being sort of sleight of hand. What do you guys think?
I think this came up in the context of he was talking about the positions that the department has taken.
Yes.
And then I think that led to the question as well, who are you speaking for the department or only for the special counsel?
Right. Yeah. So, okay. So, everybody agreed. Seemed like both parties and most of the justices agreed that they're going to have to send the case back to Judge Chutkan after they decide what they're going to do for further actions. Now, Justice Roberts, I think it was, asked Sauer, "So what do you think the procedure is?" And Sauer said, "Send it back to the district court, who then sorts out what's private versus what's official. And then you strip out the official and proceed, if you can, on just what's private." That's not what Mr. Dreeben wants. He agrees it has to go back to Judge Chutkan, but he thinks that she can kind of make rulings on what's private versus what's official and then let them use what's official as evidence and then instruct the jury about in what ways they're allowed to use the evidence. But are we all agreed on that? That it seems like everybody thinks it's got to go back to Chutkan with whatever guidance the Supreme Court gives her to take next steps on it.
If unless Dreeben gets his way, that this is all these issues can be raised as a defense. In which case, we go to trial, let the jury decide, and it go up on appeal as to the legal defenses. That I doubt that the court goes that way, but that's what the special counsel wants to happen.
Fascinatingly, he was kind of mumbling at this point, but Ship, did you pick this up in the transcript? He mumbled something like, if the court wanted to set up special procedural rules, that was something that he could accept. Sort of like, maybe they might not be totally on board with the president can't come back to them for clarification on some of these things. I got the impression listening to him that he was reading the nonverbal feedback of the justices, and they were not comfortable with this idea that, Chutkin was just going to pick up the trial.
Yeah, he wants them to, if they're going to send it back, he wants them to send it back with some kind of structure that does not allow an appeal of what she does next. Um, the structure would be that she makes decisions as to how the indictment shall read and how the evidence can be used. I think this is where the concession that Sauer made about at least 3 instances being private conduct. I thought, as soon as I heard that's like, I guess we're having a trial. As he just said, that he's not immune for private conduct, and he just acknowledged at least 3 instances of private conduct within the context of the indictment, and so we're having a trial. So what Dreeben wants to avoid is another pretrial proceeding that leads to an order that is appealable, because we'll be in the circuit court again in August,
Yeah.
and maybe back in the Supreme Court, with the first week of October. Um, so because once as we now know, if what they send back to her is a proceeding that leads to an appealable order, as soon as Trump files a notice of appeal, everything in the trial court stops again.
Right. She gets divested of jurisdiction again. Okay. I didn't hear anything. Did you, Ship, on this question you and I have been talking about for a long time, which is Judge Chutkin supposed to decide these issues based on just what's in the complaint? Or is she supposed to hold an evidentiary hearing so that Trump's lawyers can explain factually why some things are official, even though in the indictment they might be alleged as part of the case or alleged as official, that they should be able to contest that with factual evidence? I didn't hear anybody address that in the whole argument. Did you?
No, and that kind of goes to this question of, is an immunity claim resolved assuming the facts of the indictment to be true, or is an immunity, as I think an immunity claim is a mixed question of law and fact. The ultimate question is a question of law, but it depends upon fact finding by the judge, and it's subject to the factual findings are subject to review for clear error, and the legal conclusion is subject to de novo review. I mean,
Now, Leslie, I
so
heard
it requires fact
yeah,
finding.
Yeah, go ahead, King.
I heard Sauer describe a 2-step process,
Right.
and the first step being look at the indictment, and if there's anything on the face of the indictment that is objectively within the scope of the president's official duties, that's immune. And then as to and if anything's clearly private, that's not immune. And then the gray area, the things that are ambiguous or can be argued either way, let's have a evidentiary hearing or some kind of hearing to determine one way or the other. All that happens pre-trial.
Right. Now, as a practical matter, you might be able to agree between the parties that some things are private and some things are official, right? So, but I didn't hear any stomach amongst the justices to try and figure out this point that Ship and I have been hammering, which is, are they going to confine the analysis to what's in the indictment, right? Or are they going to allow the president's lawyers to adduce evidence to show what's official and what's not official?
My opinion is they won't go anywhere near basing it on the face of the indictment. There was
You think they'll actually say that in the opinion?
at least in a footnote, yes.
Okay. Well, hopefully they
Because
will, but I don't have confidence in that.
that's it. You can't do a blast. Sauer made a big push of follow the procedure outlined in Blasingame. And
Well,
and
that's
you
true.
cannot do
Yeah.
that on the face of the indictment.
Yeah. So maybe everyone's assuming the point that Ship and I are hammering on, which Judge Chutkin did not do, which is to hold an evidentiary hearing. Ship, what do you think?
Well, again, I haven't read Blasingame. So if the court adopts the Blasingame model and King, who has read it, and I think you've read it,
Yeah, I
if
have.
that contemplates an evidentiary hearing to separate, you know, office seeking from office holding conduct, and that's not just based upon an assumption of the truth of the allegations as stated, then yeah, and that's going to be interesting because
Yeah,
that's damn near a mini trial of most of the case.
the whole case, right? Exactly. So what I think is that if they don't specifically tell her she has to do that, I don't think Judge Chutkin will do it. I think she'll rule on the complaint.
Uh, the Blasingame is a D.C. Circuit
Well,
opinion,
that's true. She's
so she
bound
is
by that.
bound by
Yeah.
it if it's in any way relevant to what she's doing. Second, Blasingame did not say we're going to have an evidentiary hearing. It's a civil case, so it said the facts will be developed through discovery and summary judgment, which is based on evidence, uh, undisputed evidence. Uh, it doesn't. I don't remember it saying what happens if we have disputes of fact. It kind of assumed that the facts as to private versus uh, public would be developed some way in the discovery process. But all of it assumed would happen before trial, before it got to the jury.
Okay. All right. So that leaves me to our last topic, which is kind of what do we think they're going to do? How are they going to come out? So Mr. Dreeben basically tried to pitch to the liberals that they should find there is a very narrow, limited kind of immunity that he doesn't want to call immunity, that he wants to call an as applied Article 2 challenge that covers only sort of very core powers of the presidency. So the power to appoint ambassadors, the power to give pardons, the power to do certain things. Justice Kagan questioned him pretty closely on this. He conceded that most of the president's sort of commander in chief powers would qualify, blah, blah, blah. So it looks to me like that's probably where the three liberals will go. And then, as I said before, it looks to me like four of the conservatives, Thomas, Alito, Kavanaugh, and Gorsuch, think that that there is immunity and it should be a lot broader than what Dreeben is arguing. It's not clear to me whether they think it should go as far as the Fitzgerald court did on the civil side. To me, that's the most logical thing that they should do. They should just follow Fitzgerald because the reasoning in Fitzgerald, I think, is very sound. But it does seem to me that Justice Roberts potentially is not comfortable going that far. And it seemed clear to me that Justice Amy Coney Barrett was not comfortable going that far. So, what do we think they will do? And before you guys answer, let me say this. I'm wondering if we might not have a situation where this happens. Lawyers have an idea, judges have an idea. And this was something I learned when I clerked for my judge, that sometimes the opinion, what lawyers and judges will say is, it won't write. So you think you know how you want it to come out, but then when you sit down to write it up, you can't write it up in a way that legally it makes sense to come out the way you want it to come out. And when that happens and the opinion won't write, normally what happens then is the judge or judges who are having this problem, they have to reevaluate their position and figure out, okay, what can we do? So maybe Amy Coney Barrett is searching, her and John Roberts, for a middle position, but God in heaven alone knows what that would be from my point of view. I mean, I could be wrong and maybe I'm missing something, but what would be a middle position for those two? So, you guys, what do you think about this question?
Well, I mean, I heard what I thought was Justice Barrett's middle position, which was floating this idea for something, for essentially a pre-trial proceeding where the judge would make a decision on the existence and extent of the immunity.
Right, sort of, but
comparing
Fitzgerald
basically,
light.
yeah,
Fitzgerald light, though, not as
yeah,
far as Fitzgerald, right? So
correct. Well,
she, yeah,
it would all be established in the trial court, because she said, wouldn't this be essentially a pre-trial public authority defense?
right,
So she's creating something. Public
right,
authority
because
defense is an explicit thing. It is handled, like I said earlier, within the context of the trial, presented by the defense after the government's case, subject to rebuttal. The defendant has to give notice to the government of the intention to present a public authority defense, and she because Dreeben started down this road talking about how a president would have the public authority defense if he obtained the advice of the attorney general and the attorney general was lawful. And she said, well, why not just have that same kind of proceeding pre-trial?
and she went farther than that, Ship. When Dreeben said what Sauer is arguing goes too far, Amy Coney Barrett said, and I quote, "I agree with that." She does not like Sauer's position as stated. She thinks it's too broad.
I think she thinks that his what
All
the
that
Trump defendant
impeachment and the clear statement and all that stuff is too far. Yeah,
well,
maybe.
no, I think that the using the Fitzgerald standard of the outer perimeters is too
Yeah,
far.
too far.
So it has to be something narrower than that, but it has to be done at the trial court level.
But what in the hell is that going to be? That's what I don't understand.
Well, but that's Gorsuch's point. What the hell is it
Yeah.
going to be?
Right. Yeah. Right.
They have another problem, which is anything in between the outer perimeter standard of Fitzgerald and the no
Dreeben's core.
no
Yeah.
immunity or core constitutional immunity. Any, none of that's been briefed as
Right. Like what the
what the
test for it
test
is.
is,
Right.
how it applies
Yeah.
to this particular case or any other case. We have it's not been briefed, and as you pointed out, Leslie, at the beginning, uh, they were going all over the map with possibilities and reaching for some middle ground, and no precise middle ground was really articulated. Uh,
No, Alito was saying, what if we said that it has to be plausibly within the president's responsibilities, right? And then Sotomayor was like, what does that mean? Why are you injecting a plausibility component? Right? So to your point, King, like they are just struggling with how to do this. And to me, I'm like thinking, Jesus God, just adopt Fitzgerald. That's the only thing that makes any sense.
Yeah, but Fitzgerald just leads to the question of, well, what's within the outer limits?
Well, almost
Where
nothing
is
is
the
beyond that is the effective
yeah,
thing.
that's the effective outcome. Correct. Is that but I think the the the, the solution here, and it's probably going to, I'm not sure who would twist the arms, but the solution here is say, you know what, send it back to the trial court under circumstances where the trial can't take place before November, and maybe November solves our problem.
Right. So they're going to say the president has some immunity, right? Even if it's Dreeben's little tiny core, right? So the district court got it wrong and the court of appeals got it wrong. So basically try again.
Exactly.
Yeah.
I'm not sure I see that happening.
Well, that's in.
Hello.
Leslie, we're not hearing you. Your mic is now turned off.
Rating. Can you hear me now?
Yes.
Yep, now we can.
There we go. It reconnected me. Right. I agree with you, Chip. It's like, King, sorry. It's like that's totally unsatisfactory. Also, you can't just send it back to her and say try again. That she needs more guidance than that. She Judge Chutkin. They're going to have to say something. So I wonder if
Blasting game.
Amy,
Blasting game. Try
blasting
blasting game.
game. Yeah, that might be it. Try that. See if that works.
Yeah. Yeah.
Right.
I think they may want to see what is private versus what is within the ambit of the official duties, and then before they decide immunity in this case.
Do you think they
Yeah,
can get Amy to agree with that and be on board?
Yes, I do.
I'm not sure they. Yeah, but I'm not. Well, so here's the deal. I'm not sure they ever get to 5 going the other direction. You
Oh,
might
right.
end up with a
Exactly.
fractured
You got
decision.
3 and 4 and 2, or maybe
2.
1. Yeah.
And the
Right.
2 in the middle might control the outcome by simply sending it back, even if they send it back with different instructions than the 3 would give. Um, you have another. What was the abortion case that was 3-2-3? Um, Casey.
Yeah.
Your
Yes,
fractured
Casey.
decision
Yeah.
where the two in the middle control the outcome because of who joins them, and they might only join on the basis that it's going back and blasting game, and then basically they all reserve the opportunity to disagree with what comes back as a result of blasting game.
Right.
Yeah.
Exactly. Now, the other outcome could be that if it just won't write, if Amy's opinion won't write, and John Roberts' opinion, sort of in the middle, won't write, that might force them to ultimately end up agreeing with the 4 conservatives. And then you end up 6-3.
Uh, I have another theory, which is given Dreeben's admission that core, the core Article 2 functions might be immune, and the fact that nobody likes the DC Circuit's opinion, you might get Roberts, as the institutionalist on the court, might get a 9-zip ruling to reverse and remand. The only issue being, what are the instructions?
Right, because even Dreeben is arguing something different from what the fucking Court of Appeals said. Right? Nobody's where the Court of Appeals is.
That's my point. That
Yeah.
everybody in the room seemed to agree that the Court of Appeals got it wrong. Now the disagreement over is, what do we do now?
What's the right
Let's write it.
answer? Right.
But if everybody agrees the DC Circuit got it wrong, that's a 9-0 reversal.
Right. Right. And then they all disagree on what the actual answer is. But still, 5 of them at least have to agree on something, right?
Yes, they have to agree on something, but that can be minimal.
Yeah. Right. So it will be fascinating. One of the reasons I wanted to make this list of the stuff we covered today is to see, is their opinion going to address all these issues? Right? From soup to nuts, like Misa's thing about the appointment, all the way to what's the procedure going back. And we have detours and to how much evidentiary use can you make of it? And what are we doing about the clear statement rule? And what do we think anything about pardons matters or not? I mean, it'll take forever to write this opinion.
Yeah, it'll come out probably right after Fisher.
Yeah.
Oh, you know what we haven't mentioned? We haven't mentioned Gorsuch once again saying nobody knows what corruptly means.
Yes, exactly. He just threw that in there because this case has nothing to do with that. He is on a hobby horse on that, and God
No,
bless
well,
it.
in fact,
God
remember
bless him.
he used
Yes,
1512 as a hypo.
he
He talked
did.
about if the president conducts a peaceful demonstration
Oh, no, no, no.
outside the
Mostly
Capitol,
Mostly
peaceful.
peaceful,
Sorry, Chip.
yes.
Mostly peaceful.
outside the Capitol to oppose passage of a piece of legislation, and it's wrongful. In other words, he knows that he's not lawfully there.
Right. And it delays the vote.
Yeah.
Yeah. Yeah. Are you, Jack Smith, going to prosecute that president? Oh my God. What? But, this case has nothing to do with corruptly, but he's just going to throw that in every time because God bless him. Neil Gorsuch is my favorite justice. I love him because he's the most libertarian, and I'm a libertarian, right? He's just completely disgusted with this. Literally, he said, nobody knows what corruptly means. Okay, Neil. So I think we know where he's coming out. But yeah, that was a brilliant. And Dreeben seemed like I don't know what to do with this hypothetical. Ship, what'd you think of his answer?
Oh, I was laughing too hard to listen to the
Yeah, me
actual answer.
too. That's what I said on my Twitter live feed. I couldn't type because I was laughing so hard. So, all
You know,
right. Well,
I actually need to wrap this up, but I
yeah,
think
it's time.
we're
We're
approaching
done.
the 3
We
hour
covered
mark.
all my
Yeah.
topics, so we're
So,
done. Yeah.
but I thought, it was, and this part of this was a product of sort of the unguided nature of the missile,
Yes.
um, but it was a fascinating 2.5 hours.
Yeah, it was a
Um,
historic argument for sure.
yeah, yeah, they absolutely. I mean, I don't know. Does the Supreme Court normally have time limits on argument, or do they always just let it go as long as everybody
No,
wants to ask
officially the
questions?
time limit is an hour, but for stuff like this, they just don't bother with that. They just talk. So, yeah. All right, King, any final comments from you?
I'm done. Thank you.
Yep. The Hubs is done too. He's fallen asleep in the chair here. So
Hmm.
we will call it a night for tonight. Thank you everyone for listening. Thank you, Ship and King, as always, for your insights. And the gathering is concluded.